7 o'clock, we're going to start. So I'm going to call the meeting to order. And I want to grant permission to Westwood Media to record the meeting. And if anybody else wants to record the meeting, please let us know and we will authorize that. I will welcome all members as you come up to speak. And I am glad to see we have some members of the public here. We do look forward to hearing from you, and it's nice to see you come and attend our meeting. With that, our tradition is to step up and do the Pledge of Allegiance, which we will do now. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We're going to do a member roll call because we have one member who will be with us for about an hour who is dialing in. So we are required to do a roll call to start. So will you do the roll call, Victoria?
Bill Bruce.
Here.
John Kerry.
Here.
Jim Ferrero.
Here.
Warrant Patrick. Here. Seth Frederickson.
Here.
Mike Gay.
Here.
George Hertz.
Here.
George Mahan.
Here.
George Marone.
Here.
Christina Pedowitz. Here. Chris Peretta.
Here.
Sean Weller.
Here.
And Alan Ciel.
Here.
Okay. We do have one member who is dealing with a family illness and is out tonight. So I want to go over our process because we're one of the few boards that goes between Zoom and in-person meetings. We have felt that our hearings, our public meetings and our hearings really should be in person, especially when we take our votes at our last meeting. And the way I like to run it, the presenter will come up, they will make their presentation. Either Chris Peretta, Vice Chair, or I will recognize FinCom members who want to ask questions. If people working with the presenter also want to speak, please just raise your hand. Either Chris or I will recognize you, okay? At the end of our hearing, we do have time for public participation and questioning. So with that, I think we're going to start with the Select Board, and I want to welcome the Chair, Mary Ann LeBlanc, and I also see we have Mr. Gotti here. I do not see Mr. Prevatier, is that correct?
He is not.
Okay.
And
Okay.
when Mr. Gotti comes back, we'll call our meeting to order. Oh, here it is. So I would hereby like to call a meeting of the Select Board to order. Mary Ann LeBlanc Cummings, Chair of the Select Board, with me, Rob Gotti. So thank you, and thank you for having us.
And tonight I want to explain to everybody, we are not doing the financial articles, correct? We are just doing the Select Board articles. All right, so why don't you start with your articles, okay?
Certainly. So we have
Let me also welcome Mr. Bowman.
Thank you.
Select Board Articles 1 through 3 are street acceptances. Number 1 is for a portion of Ellis Street. Number 2 is for a portion of Porter Street. And number 3 is for Hedgerow Lane.
Are there any questions from FinCom members on any of those? Jim?
Can you identify what part of Ellis, Porter, and Hedgerow Lane are being accepted? Particularly with Porter, I think there's a gap in the middle of the street. Is that what there's a west and eastbound Porter Street, and there's a section in the middle that's not public street. Is that the part, or is it?
Sure, it's approximately 350 feet from Weatherby Drive going onto Porter, from that direction.
So if I'm on Adams and Weatherby Drive, I take a right onto Weatherby Drive, and it's
Yes.
between
Where
two
Porter,
sections
yes.
of Porter, right? Okay. Is that similar to, is all of Ellis being acquired, or
It's a portion.
in what portion of that?
It's approximately 150 feet going to, Bonnie, is it Bonnie Street? Bonnie Street. I just want to make sure I pronounce that correctly. It's not going to connect to Bonnie Street, just to make sure everyone understands that. There is no connection between Ellis Street and Bonnie Street. It's just going towards that direction.
Is it dead end? Or
Yes.
does it? And hedgerow, the same thing?
Hedgerow would be the entire street. Hedgerow Lane is it's a new development.
Okay, thank you.
Anything else?
That's it for me.
So I assume that the director of DPW has said that these streets all meet the town standards for public way?
He has said that Hedgerow meets the standards and that there's some minor work on Ellis. There is some more work on Porter, but what happened was there was a bond that expired. The town had a bond, prior administration had a bond that unfortunately expired, and we just didn't feel that it was right for the residents to have to pay for that. So we would be paying for that work on Porter.
So these pictures don't give me a lot of confidence for Ellis and Porter that the street does meet standards.
Yeah, I think for Ellis Street, I believe the director said there may be some crack sealing that we would have to do, but he doesn't anticipate a significant amount of work for that section that's going to be accepted.
This picture of Porter would suggest a lot more than just crack sealing.
Again, Ellis Street would be the crack sealing.
Okay. Yeah, that would have been, useful information to know before tonight. So the town is willing to take these over even though they don't meet current town standards.
So again, Hedge Road will meet town standards. Ellis Street, there'll be some crack sealings, minor, the portion that's gonna be accepted, we're looking at crack sealing. The rest of it's already been accepted and it meets the town standards. Porter, the section of Porter that does not meet town standards because we feel that the town allowed the bond to expire and we're taking responsibility for that, not passing it on to the property owners.
So we had a bond for it, we didn't do the work
Yeah, yes, many years ago, yes.
many years ago, okay.
And we did discuss this, Mr. Prada, at one of your prior meetings that I presented on this
I must have been
about a
asleep.
month ago.
Any other questions?
No more questions for me.
Okay, you want to go on to Select Board 4?
Okay, was 1, 2, everyone. So Select Board 4, so this has been revised. This was revised as late as last night at the Select Board meeting. So the new change, the new proposed amendment to this general bylaw will be to see if the town will vote to approve certain amendments to the Westwood General Bylaw, Chapter 184, Animals, to clarify various terms used throughout the Chapter 184 and to modify fines prescribed in Chapter 184 for compliance with applicable state law, so that the amended Chapter 184 reads, reads or take any other action there too. So what we're looking to do here is, we are looking to amend Chapter 184, and I put it under 4 categories, to make the language gender neutral, to adjust some grammar. There's a correction as far as an appointing of who appoints the animal control officer, and then to update the fines to meet the state law. So previously, there was language that talked about leashed and under control. That language is not being proposed at this time.
Questions from?
Yeah.
Yes.
So essentially, section 184-4A3 remains the same as it has been since the 1960s.
184A3.
184-4.
-4, okay.
A3.
Yes. Yes, it does.
And I read that to mean that Westwood has a leash law, that anywhere outside of your private property, your pet must be leashed.
So if you recall, the original language that we were talking about for the proposed amendment included public streets
Right.
and sidewalks. This does not. This is
Right.
the existing language that the town currently follows.
Right. That's been in place since the 1960s, at least. Right? And it says, no person, no dog should be permitted to be at large or out of control. That to me means that unless your pet is on your private property, it must be leashed. That's the way I read it.
That's not the way the bylaw's been interpreted and applied.
Unfortunately, you're right. But that's the way it reads. One other thing about this. Definition of animal control officer.
Yes.
And if you change that from an appointment from the select board to the town administrator. I got no problem with that.
Thank you.
But, you're welcome. But then, take a look at 184-7.
Yes.
And it says, "The bylaw shall be enforced by the animal control officer of Westwood and/or others who may be appointed from time to time by the Board of Select, or the Select Board." Is there a conflict there?
Not a conflict. The chief of police was appointed by the select board. So if you look at the definition of animal control, that also covers chief of police and designee. So in that section covers both. It covers the chief of police as well as anyone, the designee of the chief of police. The
All right.
board appoints the chief of police and I appoint the police, or the town administrator appoints the police officers.
So if there is an animal control officer, and you've appointed him, or your successor has appointed him or her, then that person is the enforcing officer. If that person isn't available, then the chief of police is, and that person might be, or is, appointed by the select board.
Correct.
Okay, I get it now. Thank you for that clarification.
Not a problem.
And thank you very much for providing these red lines as soon as you were able. I had them this afternoon, and I was able to go through them, so thank you very much.
That goes to Tish. Tish.
Thank her.
I
thank
did
her
also
for
want to just point out, there's one other change, and under 184-4 under violations, you'll see that in the red line version, number 6 is being stricken, and that's because it's repeated. If you read the beginning of number 5, so just wanted to clarify that for you.
Mr. Lehan.
Thank you, Chris. I'm just having a little trouble, maybe if you can make this a little bit more dumbed down for me, basically.
I'll do my best.
So, we're not changing the current leash law for dogs. I can still take my dog, and if I'm on my street, I'm walking him on a leash, but I can take him to a field and play catch with him. I can still do that now. That's basically, we're not changing the law, so that, we're keeping that in place. So I could take my dog, and as long as he's under control, not vicious or whatever, and I can go to Buckmaster Field and throw the ball and play catch with them. That's basically what this is saying,
As long as you comply with the current bylaw, yes.
which is not changing.
We're not proposing that section to change, correct?
All right,
that incorrect interpretation of the current bylaw, you mean?
as Mr. Hertz has always told me, everybody's got an opinion and an interpretation.
Right.
So that's your interpretation, this is mine.
We agree to disagree.
We agree to disagree, absolutely. I'm just asking Chris, because he seems to know this stuff better than I do.
Okay,
Thank you.
No problem.
are there any?
I've got a quick question and comment. So, thank you for the changes. This does not supersede the Conservation Commission's oversight to the Lowell Woods. They can still move forward with whatever rules that they want to enforce. So this is very separate. I know the answer to that is yes, I just want to make sure that that's clear.
That's
Yes.
correct.
Great.
Okay,
Thank you. So, Select Board, 13 is the adoption of a fee schedule for ceiling weights and measures. So just as a little bit of background for the Finance and Warrant Commission, back on January 22nd, the Select Board voted to enter into an agreement for services for ceiling weights and measures with Norfolk County. Norfolk County is currently providing those services, or providing those services to the towns of Canton, Needham, Franklin, and Rentham. We were previously working with the Commonwealth. The Commonwealth did increase their price substantially between one fiscal year and the next. After meeting with Norfolk County, Nora Lockney, myself, and our building commissioner, Michael Perkins, we found that their services would meet or exceed what we're currently receiving and also at a lower cost. And we found that, as part of that research, the fee structure that we did have, which is technically the general bylaw, did not meet some of the costs in order to recoup those. What the town did in the past is the town did not pass those costs on to those services to those businesses because the fee was very low. Because the fee has increased, even though we are working with Norfolk County, the proposal is to adopt a fee structure over a 4 calendar year period. and that's what you have before you. And this is to meet some of the more, to be more balanced or in line with other communities for this type of service.
Any other questions?
Just a question, will it be a pass-through to the business owners, or will there be a margin on top for administrative costs for the town?
The cost for the services will be passed through. The fee structure is what would be passed on to the merchants.
So like $10 will be passed on, $10?
Yes.
Okay, there's no administrative burden on the town to administer this program, or
Not that I'm aware of, but I don't believe so, but I can double check.
just to
that.
make sure we're covering any costs of personnel?
I understand, yeah.
I just had a similar question, which is, will any of these proposed fees still not cover costs for whatever reason? But that might be something you have to look at.
So we are looking at our fee structures for a lot of services that we provide. This particular one, again, we're looking at a 4-year phased-in approach. So, for example, if you look at the scale for 0 to 10 pounds, under the current general law, it's $2. You know, with the cost of invoicing and then receiving and then the service, it's not worth doing that. So we're looking at a cost to cover just for that fee of $667 in the first year, and then to go up to $20 over the 4-year period. So our services are not going to cover full costs, but they will offset the administrative costs as well as the cost of sealer weights and measures and any administrative services.
Understood. And second question, this is probably a minor thing and there's a good reason for it. I noticed that the steps are uneven, so it's sort of even step, and then a double step going into 2027. Was there any deliberate thought behind that versus?
The idea was we were looking at 27 and we moved it back to try to have it as more of a phasing approach.
Okay.
So 27 is where we were looking to target for those fees, and we're working our way backwards, almost like a project manager timeline to get those fees. So it wasn't a science to get it to a certain point. It was just a matter of to stagger those costs to the merchants.
Okay.
Okay, so,
Hang on. Is the 2026 fee for tanker vehicles a typo? Did you mean $100 flat instead of $100.01?
You know, I have to thank you, Chris. So I thought you'd want every penny that we could get when it comes to fee.
We do.
I will certainly double check that, but right now it is the $100 and 0.
I just
We'll double
don't,
check that.
I just don't want it passed by town meeting as $100.01.
We will look into that.
okay, so the next articles are your miscellaneous articles, and I have 2 questions. One is, at last night's select board meeting, 2 issues came up. The first was, I believe that the chair has asked the long-range financial planning group committee, headed up by Mr. Gotti, to look at a potential article, a home rule article, that would add a 2% fee upon the sale of a residence in Westwood, and that would be borne by the buyer. So my question is, do you anticipate using one of these miscellaneous articles, or is that beyond this town meeting?
I'm happy to answer that, George. That will not be an article going to town meeting. This is, and just to clarify and give the context, back in 2006, an article was brought to town meeting proposing a 2% real estate transfer fee to be imposed on buyers to allow for a capital fund for the town. That did not pass at town meeting, but it's something I've just been thinking about as we talk about our capital needs, we talk about what resources do we have available to pay for those needs. I thought that it might be something we should just look at as a community to see whether that's something we think would be worthwhile to bring up again and simply to study it. So I'm hopeful that the Long Range Financial Planning Committee will take a look at that, but that I would imagine would be a process that would take some time. That will not be on the warrant.
Okay, all right, thank you.
As I recall, that was whether the town wanted to adopt the Community Preservation Act.
No, this was different. We have done the CPA as well, a couple of times, and that did not pass. This is different from the CPA. This would be a real estate transfer fee, imposed on buyers. People buying property in Westwood would pay an additional fee.
Does the town have the authority to do that?
It would have to be a home rule petition.
All right.
Yeah, it is done in a couple of other communities that I'm aware of.
All right.
And as home rule, that would take a 2/3 vote at town meeting.
That's my understanding.
Yeah, okay. That will be a very interesting article when it would finally arrive, so.
If it does.
Yeah, I mean, I think, look, the pressure we're under as a town is, even a wealthy town like Westwood, we are having difficulty funding all the capital needs in this town. And so I think it's appropriate to look at any source of revenue. On the other hand, I think we're all concerned about any impact on property taxes or taxes on our residential folks. The second one I want to raise is you also indicated at the beginning of the meeting last night, and then you guys went into executive session at the end, that you're back in active negotiations with Hale Reservation on a conservation restriction. So once again, I'm going to ask you the same question. Is there any chance that you plan on using any one of these miscellaneous articles that we, as the Finance and Warrant Commission, are going to have to opine on at town meeting?
The answer is we may. And I want to clarify something you just said. What I did state last night is that the town and Hale have renewed discussions about collaborating to protect Hale's land. And we are actively discussing that. I would ask you not to make any assumptions as to what is being discussed relative to the original proposal that was made. I understand very well that time is of the essence because I've sat in your seat. And I know that, and I promise you that we will get you the information as soon as we can. And we appreciate your patience. This is an important issue. It's important to a lot of residents in town. As you know, our comprehensive plan has talked about protection of this land as a goal. So I appreciate your patience, and I promise you that we will bring this to you just as soon as we can.
I guess what I would emphasize is we have our final public hearing on March 26th, and we actually then vote. So we're under a lot of pressure to make sure that, number one, there has been a fairly open process, that we've had a chance to vet it, and that there obviously, the one question I would have for you is, are you going to build into this process something for resident input in terms of how the residents feel about this? What's the process for doing that?
It's going to depend on how things shake out, George. So I can't speak to that, as things are dynamic right now and fluid. I wish I could give you an exact timeline. Believe me, I'm well aware of the date of your next public hearing.
And given my concern about, I know we have a very, very well thought out, but very tight operating budget this year. We do have a series of borrowing articles that our capital subcommittee has been working on. Is this going to fall into the realm of a borrowing article?
I can't answer that.
Okay. All right, so I think that as soon as you can get us information that we can digest and see how it fits into, the use of funds, and whether it's a borrowing article or maybe a use of free cash, I guess we've sort of taken a look at the whole operating and capital budget holistically, and this all of a sudden puts another pause into our
I
feeling we
understand.
can look at this holistically. Any other members have questions on that or comments?
George, I just have a comment perhaps, which is kind of putting a veil over whatever the select board brings, if anything. You might consider setting up, I don't know if there'd be sort of a rapid force subcommittee that could look at the issue with a little more haste and prepare a presentation. Or not, I don't know, but I just
I
wanted
think
to-
actually what I'm going to rely very heavily on the vice chair here. We have talked about that in the past, and if necessary, it's a very good point, because I think we owe, all the subcommittees are going to be making reports to this group in a couple of weeks, and I think I think you're absolutely right. We have to have some group that will jump into it and report back to you. But I also want to make sure that FinCom members have a chance to ask a lot of questions on this. So that's a very good suggestion. Yes, we will do it. Any other comments or questions on that? Okay, thank you. So do you see any use of, and that still leaves you with a bunch of, do you see anything else coming in from miscellaneous articles to this point in time?
Well, we'll know more with the meetings that the select board have in March, the two meetings they have in
But
March.
is there anything else on your radar screen besides the two issues we just talked about that we should be thinking about for miscellaneous articles?
Nothing I've received, no.
Okay, all right. Thank you, Madam Chair, and thank you, Mr. Coleman.
Thank you very much.
Thank you. Mr. Gotti, thank you.
We can adjourn our meeting.
Yes.
If there's nothing else, I will accept a motion to adjourn.
So moved.
All in favor, Mr. Gotti? I vote aye as well. Thank you very much, everyone.
Let me ask you, is the select board, are you going to stay here in case we get, at the end of our meeting, we allow public questions. Are you guys going to be here for that? Excellent. Okay, so I want to assure the public, if you have questions on the select board raised articles, select board will be here to answer them. Attorney Goldberg, I know they've been roughing you, but not that rough. Right.
On the sideway.
We have a series of articles that are, they're select board articles, but they're actually the work, or the end, a lot of work done by the Charter Review Commission. And I think Mrs. Hyde and Mr. Cahill is one of the vice chairs, and Mrs. Hyde has been a very, very active member on the committee. So I think that you guys are going to take us through it. What I'd like to do, if it's okay with you, is at the end of each one of your articles, open it up for questions from the FinCom.
So we can get the
Presentation you can
cadence.
go through, yeah, all
Yeah.
right.
I would appreciate if I could do that, otherwise it's going to
that's
get
fine,
really
that's fine.
disjointed. And I just want to.
Mr. Lochte, welcome to you too.
We're all here. I think we're trying to get a presentation called up.
I get it. I got it. Still limber.
While we're waiting for a presentation to call up, can I just call the meeting to order since
Yes,
we
you
have a
may.
quorum?
Of course you may.
So the meeting of the Charter Review Subcommittee having been posted and us having a quorum, I'm calling our meeting to order at 7:27.
We'll have to conclude later. I'll start as soon as we've got the presentation loaded.
Just want to make sure I didn't miss, is Dottie here? I didn't want to make sure I didn't miss her.
She is not able to
Okay,
come
okay, I just want to
tonight.
make sure I would recognize
Yeah,
that she was
thank
here.
you.
Okay. Attorney Goldberg,
Paul's-
welcome to you.
Thank you very much.
George, early election has captured Dottie's attention.
Early
Early
election.
voting has captured Dottie's attention.
My wife voted today.
We got it right here.
No, that's a PDF.
Scroll down. Right, scroll back. Yep, click that. Yep, here we go.
Thank you.
Thank you.
And is it just, what is the, forward and back? Okay, ready?
Yep, go.
Great, thank you. For everybody who might not know me, I am Nancy Hyde, a member, as George said, of the Charter Review Committee. I'm joined tonight by Peter Cahill, who you've been introduced to. Peter's one of the co-chairs. Paul Fitzgerald, who is the other co-chair, is traveling and not able to be with us tonight. You've met him in the past as well. We have John Loughnane with us, another member of the committee. To my left is Lauren Goldberg, who is special legal counsel. Lauren is an expert throughout the Commonwealth in municipal law. And we've been very fortunate to have her working with us. And we also have our ex officio members with us tonight, Pat Ahern, town council, and Christopher Coleman, as you know, town administrator. We were last here before you in January, and before you on the Zoom screen, that is. And I'm happy to be here in person tonight. We reviewed our 8 warrant articles They're actually articles of the Select Board. Our recommendations to them were these 8 articles. They've been prepared by our committee, and we have them teed up for this coming town meeting. We don't need any of the reserve warrant articles. This is it. Since January, we have held a public forum, as we told you we would, and we've heard from your chair, George Hertz, the town moderator, and members of the public. And we have reflected on considerable input and feedback along the way in conducting our review. And we'll give you a presentation tonight on what we've assembled and where we're going with the articles. So this first slide, I want to just make sure we are all level set as to what's going on here. The charter itself is an important document for the town. It's really the cornerstone document to our governance, and it is complemented by town bylaws. So you often hear about zoning bylaws, and you'll hear about those tonight. There are also town bylaws, and they lay out in greater detail some specificities as it relates to things that you see in the charter. The current charter committee was formed 2 years ago, in March of 2022, and our charge was to thoroughly review all elements of the charter and put forth our recommendations as they relate to substantive items, technical updates, and housekeeping changes. Our work is done with a focus of updating the charter to serve the town's best interests as we look well into the future. We were here before you in January and at town meeting last spring. We had 2 articles then relating to the treasurer and tax collector, and we asked then that both of those positions be changed from elected to appointed or hired positions. The town meeting approved these recommendations, and they continue to make their way through the home rule petition process at the State House. So we're still waiting for those to be ultimately approved. So for our Charter Review Committee, I just want to point out a couple of other things. No, I guess I covered it. So we have the 2023 town meeting and the 2024. Sorry. So this is our committee, as I mentioned to you, and I just want to let you know a little bit more about us. These are the whole committee that's been together. We have collectively extensive background in public service, both here in Westwood and in some cases in other communities. And we have professional experience in local community service on our CVs. Peter Cahill and Paul Fitzgerald both served on the last Charter Review Committee that concluded about 12 years ago. Peter and I have both served as past members of the Finance Commission. Peter once was vice chair, I once was chair. Paul is also a library trustee, and you probably have seen him serving as assistant town moderator at town meetings. I have also served on the planning board and am a past member of the select board and now serve on a couple of other committees. John is an attorney and has provided that expertise to our committee, and he's been very involved in the community. And Dottie Powers, our 5th member, as you know, is the town clerk, and she even previously served in the Veterans Agency. So I would also like to note that Lauren, who I said is a municipal law expert, helped the town this time around, but also helped the town in the charter review 12 years ago. So we've got a lot of good bench strength. Our recommendations today are focused on 8 articles. They're the culmination of over 25 meetings we've held over the past 2 years or been a part of. We've interviewed about 17 currently elected, past elected, or staff. We have also received public input along the way. So now let's get into the articles. The first 5 articles are what we labeled substantive. We thought they merited their own warrant article. They were substantial enough that we wanted to dedicate conversation to them and make it not combine different interests within the same article. So we'll go through those articles. And I'll start with the quorum article. So when we talk about quorum, it pertains to the town meeting quorum. It's been a focus of a lot of our attention in the past 2 years. 12 years ago, the quorum requirement was changed And maybe it was actually even before the review 12 years ago, but Pat Ahern will correct me if I'm wrong. Let's say it was the 12 years ago. What happened in the change was that if town meeting continued from one night to another night, people could reconsider an article from the first night. Now, that's not a quorum number, but it's tied into the town meeting process. So tonight, what we're asking for is that the quorum that does exist for beginning a meeting and continuing meeting, we would like to only have apply to the beginning of the meeting, so that town meeting can start. I mean, more people come in, some people go, people might be there for one article, it's done, they leave, but the town can continue to do its business. So that is the nature of this article. The quorum that exists at the beginning of the meeting. It is the town bylaw which actually contains what the quorum is, and it's a nuance, but it's easier to go about changing bylaws. It's a local change. The charter changes require the home rule petition and state legislative process, so it's more complicated. So there are things that are contained in the bylaws that we have, I'll call it self-control over. The legislative body of town meeting can make those changes.
Nancy, I'm not trying to change things, but I actually think it's better to allow FinCom members, since there's just 5 of these articles here and they're in summary form, to ask questions instead of going through all of them. We do that with the planning board, and it's worked out fairly well. So I want to ask, do any of the FinCom members have any comments or questions?
Can you just briefly describe the process for getting the charter approved?
Yeah.
Just so we can appreciate the difference between.
For sure.
We understand the bylaw changes at the town level, but can you,
Yeah.
just a brief description?
So the home rule petition process is, and Lauren's here to fill in the gaps, because there'll be a few, but I'll try to give it the general feel. The home rule petition process starts locally in the municipality. In our case, open town meeting, could be a representative town meeting, whatever. Our case, open town meeting. We have an approval process that's required, and then we submit our articles to the state legislature. So it would go through our local rep or our state senator, and it goes through committee review process. And in the case of the 2 that passed last year, the treasurer and tax collector, we received feedback to the select board that they wanted some edits in the language. They look at consistency. What do we have versus language in other communities? And it's going through that process. Wish we could say it was all done. We have no control over that. We ask about it, we encourage it. And then ultimately, it has to get both the House and the Senate approval and signed off in a package that the governor would ultimately
Thank you.
apply.
Right, this may seem like an esoteric question, but what happens to a home rule petition at the end of the legislative session?
It becomes, and we can enact it. We now have it approved.
No.
if it doesn't
What happens
pass.
what happens if the legislature never acts on it and the
Oh.
legislative session ends?
I'm gonna defer to Lauren.
And
please.
because a lawyer can't help themselves, I will just say it depends. It depends where it is in the session. If it's mid-session, then it continues and it doesn't need to be resubmitted. If it's a brand-new session, which this will be, it would need to be resubmitted. But keep your fingers crossed. End of the year is typically when a lot of these local bills get acted on.
Okay, so.
To be clear, if there is no action on it, then it does not become effective.
Right.
I think is
Yeah.
what you're asking. If
So
there's no
what-
action at the legislature.
No, what I'm really getting at is, will we have to resubmit the town clerk and the town,
Hopefully not.
the treasurer?
The tax collector and the treasurer?
Tax collector and the treasurer, yes.
Thank you. I don't anticipate that you will. The legislature never gives us, a good plan for when they're actually going to act on a particular bill. But as I said, they do tend to act on a lot of them at the end of the session. And even if it needs to be resubmitted, it's unlikely they would require new local approvals, so it would just get refiled by your state representative.
Okay.
John, you had a question?
Thank you, George. Ms. Hyde, maybe you were getting to this, but on Select Board 5, what would the goal be of removing the quorum requirement? I would assume that the objective originally would be to ensure that we have a large enough body of town residents to be kind of representative. And if we
Yeah.
were to allow that to erode, I don't understand what the
No,
the
good
goal of that
question.
would be.
So, town meeting can run long.
Yes.
People can want to leave. And yet, the way our order of articles often goes, there may still be 6 or 7 planning board articles. And a lot of work has gone into those, as you can see in this process, both the work that the planning board's done, the public meetings, the reviews with you. Somebody could raise their hand and question a quorum. And if the count has fallen below, the moderator's responsible for checking how many, we are adjourned for the night. And we have to go through the process of calling another meeting, setting up for another meeting, staffing for another meeting, paying for another meeting, and getting a quorum interested to come back to another meeting.
Sure.
So it can become challenging, not insurmountable, but very, very difficult. And you have a new set of people coming in. I can go back in the Wayback Machine, when we did that, and people were being called off the lacrosse field, or come from home, come in, just so we can count a number. And it becomes very scattered and not very focused, just to get a quorum to try to do the business. And you hope enough people stay and that somebody doesn't raise their hand again.
But let me make a comment
and I
on
would
that,
say-
because let me make an observation on that. We have 12,000 registered voters in this town. If you get 2% to show up for town meeting, which maybe we're lucky to do, we get 200 to 300 people. My understanding right now, the quorum requirement is 175.
Correct.
I think the select board under the emergency legislation, which has been extended, can reduce the quorum to 45. I struggle with the concept. If you really believe, what you're telling me is open town meetings are difficult. If you believe in staying with the open town meeting law, what I get concerned about is you could end up in a situation where you drop below the quorum, and as you said, there may be some very serious planning board articles that require a 2/3 vote. A very small number of people are making that decision. So what I struggle with, and I'm not sure where I'm going to come out on this, if you believe in open town meeting, one of the risks is we have to find ways to get people to attend. But I'm not sure the solution is saying at the end of the day, we don't have to maintain a quorum. It just seems counterintuitive to what town meeting is supposed to be all about. Open town meeting is supposed to be all about.
Yeah, and so, when we consider this, we have the range of opinions initially and brainstorming it out. Status quo, keep it the same. And then an aggressive reaction to this concern would be, well, and which has been a little bit of a trend in Massachusetts, is not requiring any quorum even at the beginning of the town meeting. And that seemed, even though some of us support that initially, including me, that seems a little too aggressive here as an adjustment or course correction. And so the thinking of, well, we'll have enough to start to have that identified amount of voters to start, and hopefully the issues are compelling enough and there are enough of our residents that we stick around, enough of us stick around.
You know, that's actually a
But to
valid-
have that as a carrot or really as a stick, a threat, we're gonna
It was actually a valid point you're making, because I took a look at the statute. You can actually, or I went to the Mass Municipal Association, you can actually start with a quorum of 1 if you
Right.
want to.
Yes.
So I think you're making, I think I understand your statement.
Tried to be a balanced
It's a
effort.
struggle. I wish we would get 1,000 people to show up, but we don't. But I think I understand what you're saying.
A couple of times we have had over 1,000 people
Well,
show
it's
up.
like for, it's.
And
it's
and
all-
then, as Nancy said, they all leave
Leave,
once the
yeah.
budget articles are done.
So I understand.
Or whatever the special.
Right.
But isn't it frustrating? We only get, and then-
Well, I don't want to, let's not slam the town, though. Not everybody.
slamming the town, I'm just
No, I
saying
know,
that.
but people in the town for not coming out. We've done very well. Even when we've dropped the quorum, we've still had exceeded our normal quorum.
Right.
We've been dealing with difficult times through the
Right.
pandemic, but people come out, people pay attention, people care. It's a fraction of those that are eligible to vote, but when the big issues come up, more people come out and engage.
I'm
So,
pretty- I understand where you're going. I'm pretty comfortable with this. I think it's a
you wanna-
Excuse me,
Yeah.
George.
approach.
I can.
George?
I commend you for your last comment, because I'll give you the example. We had a meeting on a town issue at the Downey School, and the fire department had to come in because we had so many people there. There was more people at that
exceeded
meeting.
capacity.
Seating capacity than we had a town meeting.
Yeah.
But I struggle overall with several of these articles, because it's consolidating authority. And I'm not gonna use the phrase consolidating power, it's consolidating authority. We're dumping a lot on Chris Coleman. The poor guy is working.
Okay, well, let's, I mean, that's a different, different article.
It's a general concept. You're narrowing the authority. You know, the town administrator is gonna appoint the tax collector, the treasurer, the town clerk. Now we're gonna reduce the number of needed to pass laws at a quorum. It's almost like we're taking the democracy out of democracy. You know, you wanna be able to have people vote and give everybody, you know, their piece of the pie, empower the residents to be involved and to care. I understand what you're saying. To have a quorum drop and then people leave, that's brutal, because then you don't get anything done and it's just bureaucracy. I truly understand. I'm just not sure the solution is to just narrowing and consolidating the authority and taking away the people.
But it doesn't stop anybody from coming.
Nancy?
Yeah, John?
These are good comments and good feedback. I just want to assure everybody that's on the FinCom that you don't volunteer to serve on a charter review commission and go to 25-plus meetings if you don't believe in good government. So, look, so fundamentally, our charge as a committee was to consider every line of the charter, bring in experts from the town that have served in various capacities, hold town meetings, and consider all elements of, does the charter work as best as it can work right now? And if not, what are some proposals, alternatives? We had legal counsel who's familiar with what is going on in other cities and towns across the Commonwealth. So our objective is really to not diminish the power of the people. It's to promote the power of the people. It's to promote effective government. Now, I understand folks that are looking at this the first time could have a particular reaction that seems like, well, this is maybe anti-democratic or something. I can just assure you that as a member of this committee that's gone to 25-plus meetings and has read every single line of the charter backwards and forwards and considered what other towns have done and what should be our recommendation to the selectmen, the select board, our driving agenda was what will make the town government work better.
John, I think I'm convinced on the validity of this, but I guess the question I want to ask Attorney Goldberg in terms of experience, are towns like Westwood literally starting to outgrow open town meeting with social media, with the way the world is changing? Do you see towns at some point in time saying, we can't, open town meeting just isn't going to work anymore?
Mr. Chair, I guess I would say that towns with open town meeting, I don't see open town meeting going to a representative town meeting. If anything, there's discussion sometimes about going to a town council.
Okay.
But open town meeting, you know, it can be any size. And I think one of the things that I would add to the conversation is that really calling a quorum is a procedural maneuver for somebody who's in the know. And so what this really does is it eliminates the possibility of a procedural maneuver. To the extent that, you know, you want people to go to town meeting, I think the process, town meeting process is more important than saying that a certain number of people need to be there to do business. And in reality, it's on every voter to come if they want to participate. And, you know, kudos to those who stay to make those decisions.
No,
So
I think you've given me a very balanced understanding on this, and I appreciate it. Look, I know what it's like, you know, with a large 15-member committee, the amount of hours we put in. So I share you. We wouldn't be doing this if we didn't care about the town. So I'm sorry we spent this much time, but it's actually been very...
Just wait till the next one.
No. It's actually, I've learned a lot, and I've gotten very comfortable with your recommendation by having this discussion.
And and thanks to all your questions, and they'll continue because we have so much information in our heads and from our work that we're really happy to share it. I'm trying to give you a
And I really appreciate
concise,
the
but
Okay,
yeah.
next.
Mr. Chair,
We have one.
Yes.
can we stay on this topic for 1 minute?
Of course you
And ask
may.
questions about it? I have two questions, and the first would be directed at the whole committee. It's what happens under this language if there's a motion to reconsider later in the night after there's no longer a quorum? Would that still be valid?
Yeah.
And I guess the hypothetical scenario I give is let's say we've got a town meeting, we've got a contentious issue that comes up early in the night. It brings out a lot of people, and ultimately, you know, despite perhaps a FinCom recommendation or what the select board has advanced, the town votes no. Later in the night, we're on to housekeeping articles. It's 11:30 p.m. We're down to 30 people in the room who want to stick around, and most of the town's left because they think the contentious issue is over. And then there's a motion to reconsider from perhaps, say, the FinCom members here and remaining select board members and those interested in the town, and we get the article passed that the town voted against. I'm a bit concerned about that, but would that be totally permissible under this?
It would be permissible, but the more town meetings you go to, the more you'll be aware that often when an article, like what the hypothetical you've given, fails, or let's do the converse, passes, but a lot of people are there that wanted it defeated. Procedurally, people may go through the reconsideration right then, so it can only be reconsidered once. It would prevent it from coming back 3 hours later with a smaller group, whatever. I mean, you can figure out the dynamics, but procedurally, people will often try to put that one reconsideration opportunity to rest.
And that makes sense. If we change the charter, though, will people, if they're crafty, start to respond to the change?
People should.
That makes sense.
People should stay at
People
town
should
meeting.
stay at
That's what
town
Warren's
meeting.
saying in my ear.
I think that it's important to recognize that people are the legislative body. And so right now, they could have a reconsideration later in the meeting. No one called the quorum, but there's less than a quorum, and reconsideration could pass. So reconsideration itself it's a parliamentary tool. And for those that use it kind of craftily, as you said, it can create differences in the outcome of meetings. So people should stay.
And I could be wrong in this, but doesn't a motion for reconsideration have to come from the prevailing side?
Mr. Moderator?
Depends on the line.
What's the rule?
I believe it's the prevailing side.
That's what's supposed to happen, but if you vote with a clicker,
Who knows
knows?
who you voted, right?
Well, the moderator asked.
he decides.
I guess what I'd say on that front then is if what you're saying is that people should stay at town meeting, then why remove, I'm just thinking like a logical
Because they
philosophical
do
argument,
leave.
why remove the requirement? So this brings me to my second question. Attorney Goldberg, welcome back. You were a wealth of knowledge last year. Really happy to have you here. I'm curious what you've seen in other towns. If other towns have moved away from either the quorum requirement throughout the whole night or even a quorum at the start of the meeting, is it habit forming? Like, do people start to lose their civic habit of showing up for the whole evening because they're like, oh, I don't really need to? Does that make sense?
Certainly, Mr. Chair, through you. So I can't answer the second part about whether it's habit forming, but I can tell you that there's many, many, many towns that have open town meeting that have no quorum requirement. And as Peter indicated, the quorum requirements have been being lessened in many communities. That was one of the parts of the municipal relief that was provided under COVID, but it's a trend in that direction. Again, I think the idea is that as a member of the legislative body, it's your responsibility to be there, and the idea of not having to get a quorum come back out is because, as we know, a second night can be a really hard thing to get people to come to. And so rather than leave that tool out there for someone who's looking to delay or looking to have the town meeting come back on another day, this essentially says, as long as we have enough people to get started, then we know people know about the warrant, we know people are engaged, and hopefully they stay.
That makes sense. Thank you.
Good, thank you so very much. Very thorough discussion.
Great.
Can I just add one thing?
You really want to do this? Yes, of course I will.
Well, I actually do for good reason. I think everybody here should feel great that we live in one of the most democratic places on this planet, okay? Only 10% of the municipalities across the country have open town meeting. And as a registered voter, you are entitled to vote on everything from every one of these warrant articles to budgets to
you know, the bonds that we pass for borrowing articles, all of that. So this is not meant to discourage anybody. In fact, George, you mentioned that, you know, what the history of turnout has been. I did a little backtracking, and over the last 10 years, we've averaged only about 3.5% of registered voters who turn out. So we'd love to see more participation. We'd love to see more people. So I just don't think you can find a more democratic place on earth than Westwood, Massachusetts.
Thank you.
Rob Gotti, 55 Rock Meadow Road.
Yes, please continue.
My pleasure. The next article is about our town clerk, not who the person is, but the position. There are several reasons why we think it's in the long-term interest of the town to make a change to the charter, and the change being proposed is like what we proposed for the tax collector and the treasurer, changing it from an elected position to an appointed position. In its current form as an elected position in our charter, the town clerk is not required to actually be in town hall day to day, and there are actually no requirements on the town clerk, and the position is a paid position with benefits. We are fortunate that we have a town clerk who doesn't work that way and is extremely dedicated to her job and would like to be here tonight. And by the way, says if anybody would like to talk to her about what she does for the town in her role as town clerk, she'd be happy to have that conversation. The primary goal, as we see it, is to have any future town clerks in the town conduct the role according to the same professional standards that it's now being carried out. And we have listed here many of the requirements of the job. I will note that the current town clerk, because she was doing such a great job, in 2014, the town went through the town meeting process to change her as a tenured employee of the town. But, so she doesn't have to go through that regular election cycle. So in fact, we've been operating almost as a hybrid position. We all got to interview her for years because she was elected to the job, and then we said, no, it's yours until retirement age, which is 70. And the way the article, as we're proposing it, is written, if she were to stay in the job, Mrs. Powers, past the age of 70, she would become the first appointed position in that job. We did not want to try to do this now and create confusion and lose the talent and the skills that she has in performing her duties.
So in about 30 years, you say?
At least. Yep. Some of the responsibilities that we've listed here, the town clerk is responsible for the oversight of all elections locally, at the state level, and federal elections. That includes the upcoming primary, it includes early voting. You all know it's grown. The nature of the elections has evolved, and there's a considerable amount of work that goes into preparing for those elections. It is the licensing center of Westwood where licenses are obtained, marriage, dog licenses, et cetera, et cetera. There's a great deal of day-to-day work that goes into that, voter registrations. After we're done with town meeting, many of the articles that get approved have to go to the Attorney General's office for that level of review. That happens because the town clerk makes it happen and then receives back the results and incorporates any changes. If it's zoning bylaw changes, it has to get incorporated into our zoning bylaws. There's a lot of documentation process that goes into that, as an example. Public Records Access Officer. We have tremendous number of Freedom of Information Act requests that go through the town. They start with the town clerk, who has to distribute them to the appropriate parties for further review and handling. Updates to the town charter. If this were to go through, it comes back after it goes through the state legislative process. The charter has to be updated. Town bylaws have to be updated, et cetera. Justice of the peace, notary, et cetera. And Dottie has mentioned that she has a list of over 270 responsibilities. I'm sure it's a checklist with a calendar tied to it. So it is a big job. And her discussion last night with the select board, she noted a couple of things, and one that really resonates is once she does decide that she has completed her tenure as a town clerk, she strongly believes that whoever is hired needs to be experienced in a town clerk's office and understand the nature of the job and not come in as a novice. There's that much involved. There's certifications involved. There's ongoing education involved. So if it stays as an elected position, you could elect a person now. 3 years from now, a new person could be elected, and it could go on. Maybe not, we don't know. What we're doing with this article is trying to do our best to protect the town's interests, and that is such a central function of town government for all of us as residents that we believe very strongly that changing this to an elected, from elected to appointed is important. One thing we had outstanding until last night was the question of who would the appointing authority be. And we had that discussion with the select board. They carried forth a discussion about should it be town administrator appointment, should it be a select board appointment. They talked about the pros and cons. Select board, they're elected. The town clerk oversees the elections, but the select board is responsible for hiring the town clerk. That felt a little bit concerning, I would say, to some of the members of the board. Town administrator would be involved regardless, as the select board sees it. So what we received back and what the select board landed on was the appointing authority would be the town administrator in consultation with the select board. So that's this article.
Is that language you're going to incorporate into?
Yes.
So that will be new language that will be in the article?
And what you will have, we'll talk about the language tonight, but
Right.
you will have a final set for your next public hearing. That just came, as I said, out last night.
That's fine, because I
Yeah.
watched the meeting last night, so it'll be the town administrator in consultation with.
Select board.
Right, okay,
Excuse me, George?
yes.
Currently, there's a residency requirement, obviously, because it's elected. Will you be carrying that forward for residents?
That's not included in the language.
So I have a question. Given the amount, that this person is responsible for, some of them seem to be administrative duties related to town services, and then others have to do with very sensitive matters like managing elections.
Yeah.
I think the sensitivity around this maneuver is around that function regarding elections. Have you considered bifurcating the role and assigning the administrative duties to somebody on the payroll, an existing appointed position, and leaving the election-related functions to the elected position? Because I think if there's any sensitivity around this maneuver, it's around the governance of elections themselves.
Yeah, there's a staff that works in the town clerk's office, and their shared responsibilities. Dottie could tell you better how she covers it. The staff is also involved in the election process. There's a tremendous amount of work. They have to review the machines. They have to train all the election officials. I don't think it can be, clean line of bifurcation.
Well, some of it makes sense, and I agree with that, but I guess what I'm reacting to is dog licenses, burial plots, vaccinations, things like that.
Yeah, there's staff that works with her to conduct that work.
Okay. Well,
Do you want to say
I
something?
can say something about
Yeah,
elections.
please.
Mr. Chair, through you, if I may. So I think it's really important to understand the way that state elections work in municipalities. So under state law, the town clerk is the chief election officer of the town, in addition to having state laws that govern all of these other things and naming the town clerk. But there are a multitude of checks and balances that are in place under the state law and the regulations that also implement the law. And all of the elections functionality happens under the watch of the Secretary of the Commonwealth, who is the chief election official of the state. You have to know what those different requirements are, and you have to follow them in order to run a good election. And so what happens is, and I think what the clerk is is, you guys have one of the best clerks in the Commonwealth. I mean, she has an amazing reputation, and she does an amazing job. But you have been using her as the clerk since 2014, and I think, as you said, it's kind of like a hybrid, because she has to, she's an elected official, but she's also been there for all that time. And she has all those qualifications and everything. The concern is that someone comes in who has no training whatsoever, that has to meet all of those standards, and that doesn't. And we do see a turnover in clerks more frequently now. There's a lot of new clerks this election cycle, and it's going to be interesting to see how everyone manages. But one of the things that, that this will do is it means that whoever this person is, when they come in, they would have the qualifications, they would have experience. And in terms of residency, really, I mean, the only people that would have experience from Westwood would be the employees if they're from Westwood. So it's a very narrow space that you'd be looking. This is the trend. This job is very significant. And we mentioned the public records access officer. That in of itself is probably a full-time job. So you do need people who have that experience. And I know you talked about this with the treasurer and the collector. Ideally, you have a great person in office so you don't have to worry about it. But this would set you up so that this next stage, the validity of your elections, the transparency with which they're conducted, et cetera, would be, a guarantee versus just kind of keeping your fingers crossed and hoping for the best. And I don't want to put down anyone who runs for a town clerk, because they are very brave, braver than me. But it coming into it cold is a huge, huge disadvantage, in my opinion.
Chris first, then.
All right, I'm sure Attorney Goldberg would appreciate this question. I have to ask it because I was trained in the law. So, to the Charter Review Commission, what do you mean by, quote, "in consultation with," unquote?
The town administrator I'm not the select board member. I would tell you what I think it means, and what it should mean.
Yes, please, that's what I'm asking.
Yes, I just wanted to qualify that. The town administrator would probably work with the select board to prescribe a process, a screening process, an interview process, maybe even include a select board member. That depends on who's running the town and who's on the select board at the time, and probably narrowing down candidates. What it would not include, in my assessment of that language, is a public interview of the finalist candidates, which is generally the culminating event to hiring the fire chief, the police chief, the town council. Ultimately, superintendents of schools are similar, where you become one of 3 finalists, or 2, or 5, however it gets shaped that time. And once you become a finalist, you become public. So there is different kind of exposure there in that public process. So it's a bit more of what it doesn't include than what it does. It would be prescribed by the then select board and working with the town administrator. What do they want? But the town administrator would be responsible for the process and for completing and coming up with a candidate, and probably would say to the select board individually, this is who I'm going with. Tell me if I'm missing something. I mean,
So a follow-up question, was that 3-word phrase, were other 3-word phrases talked about? Was that a compromise? Was
a
this-
compromise, you could apply that word. I mean, what it was a good conversation about the pros and cons.
I think
If
town
it was,
council, I think Pat wants to weigh in right behind
Thank
you.
you.
so-
We already have this in our charter in another place. 10 years ago, or 2010, when we established the finance director position, the finance director is appointed by the town administrator in consultation with the board of selectmen. We've done that once recently, and I think it's worked out magically for us. We've got an excellent new finance director. So I think that's what illustrates how we would probably go about it, Mr. Purdy.
Thank you very much. That's
yeah,
very
thank you for
helpful.
that
Thank
question, Chris.
Chris, you stole my first question, so that's great.
Ask it again.
Yeah. Second question would be, I know you've discussed the certification requirement, and there's now a certification for town clerk responsibilities, which I think is indicative of the professionalization of this role. And I think a lot of what you've laid out makes a lot of sense with respect to that. It's, Dottie's got 275 things to do. We want somebody who is capable of handling all of those responsibilities. I have absolutely no doubt that our current town administration would hire somebody with that certification, but I'm wondering if that's something one would ever build into the charter or some part of the qualifications itself, just to guarantee that going forward, if that is in fact our goal.
I'm going to let Lauren address that.
In my experience, putting particular qualifications in a charter isn't a great choice. It would mostly be directory rather than mandatory, meaning an appointment could be made anyway. And it creates kind of distrust in the charter if it says they must have X certification. But I do think, you know, from the discussion last night, that everyone was aware that the point of trying to deal with this is so that an appointment can be made or a hiring can be made of a qualified person. So that would be something, you know, the select board is directly answerable to the voters and the town administrator is directly answerable to the select board. So there are checks and balances there.
And we also have a human resource department. One of our discussion items tonight will be the personnel board, but there are job descriptions, there are classifications that exist. So there is a way to keep standards going forward with new people in positions.
That makes sense. Thank you. And third is a comment, because I personally am in support of this. I did know, I looked kind of through the towns immediately bordering us. All of them except Norwood continue to elect the town clerk position, I believe. And Norwood has it appointed by their select board. So I'm just curious if, you know, looking at the experience of other towns, my understanding is maybe more are going in the direction that's proposed here, but those who have held off, and maybe this is a question for Attorney Goldberg, those who have held off, what are typically some of the greatest concerns?
Well, exactly what we're talking about. And a lot of times you'll find that the clerks that are elected will get reelected over and over and over, and I think it's for the same reason that we're discussing tonight. You know, when people are going to, when someone says, I'm not going to run for that office, that's when you see kind of a discussion start about who would be best situated, and typically, you know, people keep their fingers crossed for someone from the office who's a resident.
Okay.
That's what you typically see.
Last question.
Peter has something.
Could I just respond to that? So, you know, we try to think about peer communities and towns, and when the Division of Local Services came, they suggested some of our peer communities. I know our school system, we think of other towns that are our peer communities. So we just did a quick assessment, and it's mixed. I agree with you. It's mixed as to whether they're currently, the town clerk is currently appointed or elected. But towns like Acton, Winchester, Sudbury, Concord, Wayland, and Weston are all appointed. To your point about some local communities, Medfield is still elected, and several others, Wellesley, Hingham, Marblehead, Hopkinton, Duxbury, just to give you a sense of, these were towns that we think are our peer communities, and the Division of Local Services thinks are peers relative to population and demographics and per capita income, that sort of, so.
May I ask one or two questions?
Yeah, one more, how's that?
One more, okay. Would this be appointed indefinitely, or would there be a term of 3 years still? So you mentioned Acton, for instance, and Acton has an appointment by the select board for 3 years. At least my research shows that. So I'm curious, I see a mix in terms of the data that I had, but I'm curious what.
Well, I would think the intent is this is not an indefinite appointment by the town for the subsequent occupant of this office.
Yeah,
That's not the intent at all.
Yeah.
Okay.
And that's something that the select board and town administrator would need to
All right,
determine.
thank you.
Are there any other questions? Just one final comment I'll make. I actually participated in one of the searches that the town administrator set up for our wonderful finance director, and I thought it was a very thorough process. It was a very carefully written job description. I believe that job description was vetted with the select board. There was an intense interview process. There was a scoring system. And at the end of the day, you know, that committee had the opportunity of making a recommendation, but I thought the process was extremely thorough. And my sense is if we go through a comparable process for hiring the town clerk, it'll be a very, very healthy process.
Yeah, depending on the position, there are different things that get done. For instance, if it's police chief, there's an assessment center type addition, which role plays scenarios so you can see how candidates respond to stressful situations or whatever. So it gets customized depending on the position.
I'm sorry to do this, but George just poked another question into my head. Would this make it more difficult to remove a town clerk?
No.
If we
I
wanted
was
to?
going to say, the difficult thing is the elected process and to do a recall if you have somebody who's not qualified in the job or not performing well.
Okay.
That's difficult.
This person would be an employee of the town bylaws and rules and
Right.
to
That's what I'm getting
removal
at.
for bad behavior.
Whereas the police chief and fire chief are appointed by the select board, and hence they can be removed summarily by the select board.
Whatever it says in their contracts.
Okay. All right, thank you.
Good.
Personnel matters are
Personnel.
complex.
Personal.
Personal, no, complex. They involve a lot of different players, for sure. Okay, so let's talk about the Finance and Warrant Commission. You know, we've been at this one for a while, and hot off the presses this week is amendment to our prior review with you in January, where we were discussing having the possibility for the membership in the Finance and Warrant Commission to drop down to 11 members. What hasn't changed, we've taken that out, by the way, what hasn't changed is the idea of having flexibility for the moderator. And the moderator having the ability to not appoint, if doing so, it comes at a very disadvantageous time of the town meeting cycle, or there is difficulty in finding qualified candidates. Those points we've been talking about all along. So the new amended language would address those points and contain information spot on to that, but it would not have a lower number drop down that is, I don't want to say prescribed, but targeted or however people may interpret it. That will be removed. And the language.
Can I just comment on that?
As a best efforts.
Because I
Best efforts, yes.
just want to
Thank you,
comment on
Warren.
that part. I want to say that I ended up having a very healthy discussion with the Charter Commission at the recent meeting. I happened to watch a lot of the town meetings as part of my responsibility as chair here. They did invite me to participate. And I have to tell you very honestly, I was a little reluctant to do it at first. I know you almost had to ask me twice to join in, but we ended up having a very, very healthy discussion. And just the points, and I thought we ended up with an excellent conclusion, which I didn't know about until I saw the language, I believe, yesterday. And the point I made is, when Chris and I first met with the Charter Commission, we were actually talking about maybe dropping down to 9. And what we said to them, it would be much easier for us to manage a committee of 9 or a committee of 11. But honestly, what I've learned over the years of being on this group brings a tremendous amount of diverse opinion and thinking to the Finance and Warrant Commission. And it's almost, to be honestly, to me, it's the largest committee or commission in town. And even, you know, we talk about the small numbers we get showing up for town meetings. I think having this diverse representation and difference of opinion is extremely important. So my final, and yet at the other hand, I understood that I wanted to make sure we were in compliance with the town charter. And so I think this is an excellent solution here. It does give the moderator flexibility not to have 50 members at any point in time. The key issue being, we really need our membership on board at the beginning of the year. Maybe the first quarter, it's okay to have somebody join. Once we engage in the full process with all of our subcommittees and all the work we put in, very hard to integrate a new member. We've done a wonderful onboarding 10-page document which Victoria and Chris put together. So I wanted to make sure that the moderator felt comfortable and had flexibility, but I also believe very strongly in trying to maintain a broad group. So it was a half hour, a very interesting discussion. I thought it was very creative. There was a lot of give and take, and I am extremely pleased with the recommendation they've come out with, and I hope the moderator is comfortable with it too, in terms of giving him the flexibility he needs.
And we talked about it, as you know, last night at the select board meeting. They are comfortable with this language. We are. Sometimes things take a little bit longer to bake and get amended, and here we are. I think we have a better answer to this objective of trying to make it work well, but acknowledging the circumstances and the challenges that can
And I want
sometimes
to say,
exist.
one thing I did at the meeting, by the way, I made it very clear, I was speaking on behalf of myself. I felt that I did not want to say I was reflecting the opinion of the FinCom members, because I always respect their independent opinions. So if any of you have any comments or concerns, I want to hear about it, but I was basically espousing my philosophy, which you probably heard me say many times, but I also want to respect the fact that I was speaking on as chair, not representing all of you, because your opinions may be different than mine.
Part two, oh,
I have one quick thing to say. So I want to do a little commercial. So having joined the FinCom a couple years ago, it's amazing, and it's the best kept secret because you get to really learn how the town works. You get to hear the business of the town. You get to give your opinion, which sometimes differs from others. So I'm blown away by the low turnout at town meeting. I'm also blown away that we don't have so many people knocking on the moderator's door to get this job. So please, if you're out there watching on TV, throw your name in the hat, because it's an awesome thing. Yeah. So it's just
Jim
a little
appreciates
commercial.
that, yeah. I'm sorry, more on that.
So you guys also looked at the bylaws, too.
We did not, as part of our work. That will be following up on this work will be a bylaw review
So
by another committee to be appointed by the select board.
all right. My point is only that the provision in the bylaw that relates to this particular issue is a little bit more direct. As I read it, it says, Finance Commission shall be 15
It will need to be
voters.
updated.
Yeah.
My question to Attorney Goldberg is, which document takes precedence if you interpret that as a conflict?
The charter.
Okay.
The charter?
Yes, the charter has the status of a general law in terms of dealing with bylaws, and it supersedes some general laws as well. So the charter is at the top.
Right. And you may not even interpret that as a direct conflict, but, okay. that's
Which
good.
just underscores the importance of all our time here to try to do it right.
Okay.
Part two?
Part two.
Part two. A little bit of a history lesson. I would say back in the late 80s, early 90s, an article was passed at town meeting that disallowed a Finance and Warrant Commission member from running for office in town and serving on the Finance and Warrant Commission. I believe, I don't know for certain, but I believe at the same time it was added that you couldn't serve on other boards and commissions, not, beyond the elected, appointed. We went about our merry way and didn't really pay attention to that and had FinCom members serving on other committees. And as soon as it was brought to the town's attention, that discontinued. It's a loss. I know, George and I both know, we've served on committees in the past when I was on the select board. Having FinCom members on some committees is helpful. And this is another one where we've tried to find the right balance because you are opining on articles, so what we're putting forward is ex officio status, non-voting. But going back to allowing it, it doesn't mean every board and commission would have a Finance and Warrant Commission member as an ex officio member. There are times when it works. I think long-range financial planning is one of those, in my opinion, that it used to work quite well on. And now that that committee has been reconstituted, maybe it will be something the select board wants to do going forward. That's for them to decide if this gets passed. But that's part two of the amended language for section 731.
does that go both ways? So FinCon members can serve on another committee as non-voting, which initially, as you know, I was against this because I felt that there was no independence. You just squashed my whole argument, because by taking away the non-voting, they're purely advisory, which may, if I served on another committee, I'm purely advisory, just like any member of the town could do. I could speak, any member of the town could
Right, and you
speak.
also get more knowledge that helps in the deliberations here.
Does it work that way, that they can serve on the finance
No.
committee? Okay. You squashed me, so you're all set. Good to go.
Hope I didn't hurt you.
I'm
Sorry.
okay.
Good squash, good squash.
I have a quick question, 2 questions on the first part of this. How will this affect the quorum for the Finance and Warrant Commission?
Want to speak to that?
Does that adjust accordingly? Will that require a separate bylaw change?
So the charter, the proposed charter amendment to this section, which is in the town moderator's appointment section, says that quorum is a majority of those then in office,
Okay. Thank
to
you.
preserve the ability of the town to act.
But that, it's in direct conflict with the bylaw, which says a quorum is 7.
Mr. Chair, through you.
Yes.
Yeah, so the bylaw will, if the bylaw is inconsistent with the charter, it will not apply. The charter will supersede that.
But do you think that's a good idea?
The town's gonna follow up and update the bylaws.
No. Is it,
7 to 8.
is it,
Oh.
is it a good idea to make the quorum of this commission raise from 7 to, 8?
Mr. Chair, so the way that would work is if every single member is appointed, then the quorum would be 8. If there was a vacancy, then the quorum would go down. To allow the commission to be able to do its business.
This is a wrinkle that I didn't appreciate before.
My second question, which may be sort of out of bounds for this, but what happens when we have a split vote? If we've got 14 members and it's 7 to 7, is it
It's no action.
no action?
Mhm.
And for purposes of town meeting, does that advance as the
No
indefinite
recommendation.
postponement?
No recommendation.
No recommendation, okay.
But it could still be taken up at town.
George, you don't split the vote?
I will have to tell you, I'm not going to mention how many years I've served on this commission, but I don't ever think we've had a split vote.
The closest we had was 7 to 8.
7, 8.
And that was last, 2 years ago.
Right.
Okay,
Yep.
let's not do that tonight.
No.
I've got a quick follow-up to the 7 versus 8. Is it possible to amend at this point to have 7 if 15 are are appointed, or half? So that wouldn't be increasing from 7 to 8 with a full 15?
We can consider that, I suppose.
Yeah, I think the committee would have to discuss.
Yeah.
Because that would be the only negative change that would,
We know we're coming back at the end, later in March. We don't intend to come back with any loose ends, but if you want to create a loose end,
We'll tie it.
George,
Yes, Jim.
just for clarification, we can only vote it up or indefinite proposal?
postponement.
Or, right, indefinite postponement. So would a tie, is it still a no decision, or does it fall into the indefinite postponement category?
I would defer to town council, but
I would say it goes to town meeting with a split decision and no recommendation.
So then does that give the board the authority to make a vote of no recommendation? We got a third option now.
Procedurally, perhaps it does if you had, 14 members.
What happens if a majority wanted to vote no recommendation?
That's not one of your options.
That's not one of your options.
Under the bylaws.
Now you're taking liberty with your options.
It's just like in Nevada, you can vote for none of the above.
Right.
Well, you
Nevada's
can,
a long way from here, Mr.
you cannot vote. You cannot vote. You can also be present,
Abstain, yep.
Yeah.
there are different,
Abstain.
and just because you might have 15 members, which is a nice idea to have an odd number of members, it doesn't mean all 15 are going to vote. There are a lot of what-ifs. ready to
I
go on?
would say that I think one of the uniquenesses about this commission is more often than not, we tend to reach a consensus article. May not be unanimous. There are times, though, when we've had some very close votes, which I think is extremely healthy. And I think that's part of our process. I think, to be honest with you, if we ever had a tie vote, I think we would probably find a way to think it through and come up with a way of making sure we delivered some form of recommendation to town meeting, because I think it's our job, our obligation. So
That
I
makes
think
sense.
it's a challenge. We've struggled through it.
Yeah.
We try to get
It
through it.
makes sense. I mean,
Yeah.
there are different scenarios you can't predict.
You also have the power of the pen. You get to write up your founding. So
Right.
where you have a majority and minority opinion on certain things, if you have a tie, you can have
Right.
two different opinions for people to consider a town meeting.
Yeah, and that's an interesting point I want to emphasize. One of the things we do is we respect, the fact that we don't always have, a supermajority vote, and we always try and discuss and at least put in our recommendation what some of the concerns were. We actually have a sync check. We ask those who, if it's a 9-5 vote, well, somebody on the 9 side will write the article. We pick somebody from the 5 side to review it to make sure we are representing their concerns. I mean, we spend a lot of time trying to balance that.
You did a minority report too, George.
Yeah, so if it's big enough, we'll actually do a minority report.
You did.
Yeah.
Mr. Chairman, since this is a public hearing,
At
we're
the-
not hearing from the public tonight.
Sir, the way our process works, at the end of this, and the town officials are going to stay, the way we've operated is we will give you as much time as you need after we finish the formal part of the meeting. Okay? You will have as much time as you need.
That's what I think he wanted to know.
Yep.
I could hear him a little better. Okay?
Yes, very good.
So we're going to hit a faster clip now. Personnel Board. We are recommending that due to the evolution of the role of the HR department, the HR role, that the Personnel Board is evolving as well, and we recommend a name change to the Personnel Advisory Board. Going back in the Wayback Machine again, there was a time when we didn't even have an HR director. We had administrative support only to the Personnel Board. We've had an HR director. This is now our third, have our third HR director in a number of years. We've had outstanding people in the role and do today. And the role of the Personnel Board up till now has been to handle classifications, compensation plans, but if there's any negotiation taking place to hire somebody, staff has had to go back to the Personnel Board. They have to be assembled, they have to have a meeting, and it creates a timing issue. And when you're negotiating with a desirable candidate who may have other job opportunities, that timing could be dangerous. And so we're evolving again. The recommendation is a personnel advisory role, and it shifts the role from administrator of these plans to advisor.
Any questions from, okay, next.
Great. Permanent Building Commission, this is pretty straightforward as well. There's one item to expand and provide for more prior professional experience in the people that get appointed to the commission. We want to reflect that a school committee member needs to be on any school building project. It's state law. We want to embody it in our charter. And there are projects that, $100,000, while it's not a small amount of money, generally represents a small project. And so we actually want to set the threshold to $1 million. Even $1 million projects might not always be worthy of being overseen by the Permanent Building Committee. I was trying to think of an example, and I would think like a roof project. We have personnel in both the municipal and the school sides who are capable of overseeing those projects. It doesn't need to channel through the Permanent Building Committee for bill payments and working with oversight of whoever the contractor is. So this is one of those articles I think really reflects how things have evolved, and it's codifying a better practice in today's environment. So it's not particularly complicated. Okay?
Okay, any questions?
Everybody good?
Yep, go.
Okay, so we have a package of things that are technical articles. My goal tonight is to not walk through every technical change. I think you've got a black-lined version. What we did is we looked at things that we thought weren't substantive, but needed to be changed. I've put an example up here to try to give you a sense of what that means. So previously, under section 261, we had something that said business sessions of the town meetings. We were like, huh? Let's just call it annual town meetings. And we then on part A, we're very specific because now we have the May town meeting and we can have a fall town meeting. We've always been able to call special town meetings. So this particular section, we were referencing the spring annual town meeting. We're trying to do things to make it, when you read it, you understand it. Some of the things were a little clunky.
Town Pat, just a quick question. You comfortable with all these technical changes? Pat?
Yes.
Okay. And I know we have several lawyers here, so you've had a lot of lawyering on this. Any questions?
Sometimes I feel very left out in the crowd when we're in the meetings. I am not an attorney.
Jim?
Maybe, well, I guess the housekeeping is going to follow this, so I'm just going to sort of jump in here. Do you have the same redlined copy that I have, that you circulated?
We will find out quickly.
Okay. Well, we received a copy recently, and I was told there weren't any changes from a prior copy. So I guess the original point is, I'm not sure what was the difference between housekeeping and technical, but a lot of the red lines, I think, overlapped, and I would just ask that you review it a second time, because some of the punctuation or wordings doesn't make sense.
We have, Jim, and I appreciate what you're saying. We were actually even going through it yesterday because I saw some things. We're all looking at it multiple times, and I appreciate your words of caution. We want to make sure that when we come back in March, there's a final version, because that's what you're going to be voting on.
Can you maybe, if you can get us that final version, several days before the final meeting?
Yes.
So I know people.
My
like
only
Jim will vote.
caveat is you've asked for us to look at something in the Finance and Warrant Commission.
Okay.
So that piece might, I don't know,
Okay.
We've got to convene another meeting,
Okay.
which we hadn't planned on
I can
doing.
just follow up on that.
Yes.
So the big question I had is, there was a provision, 4.61, where you allowed for the voting of associate members. And you've stricken that, and now you're allowing appointment of 2 associate members to the planning board.
You'd like to know more about that?
Well, and then the associate members can step in the event that an elected member is not available.
Right.
So now you have a non-elected member voting in an elected board.
Yes,
Okay,
that's
go
correct.
ahead.
State law provides for that, actually. So right now, the planning board can have 2 associate members, which would be appointed, and they're allowed to act on certain things.
Why wouldn't we keep them, the associate members, elected instead of appointed?
From my understanding, they haven't been elected.
No, they haven't, but we have that language in the charter to elect them, and we're striking that and now just making them appointed. Why don't
No,
we-
it's appointed now. I'm not sure.
They were, yeah, it's in the charter there.
4.61 was,
But they weren't elected. They were appointed. If you looked like halfway through, it says the associate member shall be appointed for 3-year rotating terms.
well, the language is stricken. 2 associate members of each board elected under this chapter may participate. So when it reads 2 members elected, are we talking about the elected board or the elected associates?
It's the elected board.
Okay. So
So-
should we consider electing the associates?
They are voted in a joint meeting of the Select Board and the Planning Board. So there is that level of election, not the ballot election. That's how they are chosen, and they are needed in the Planning Board because many of you may know that on things like special permits, in order to be approved, you have to have 4 votes in favor. And if there are 1 or possibly 2 people who can't either participate because they're conflicted out or they're traveling or whatever, they don't meet the criteria to vote, you can't even hear you can't respond to the submission of a special permit request. And that, I believe, What kind of legal action does that allow for? It allows for legal action from the applicant.
Now, I understand how the process works. I'm just wondering if it was considered to
No.
town-wide elect the associate.
It was not considered.
Right, one other one. Moving over to Chapter 7, 7.3.2. So it talks about the Finance and Warrant Commission. We talked about the amendment, but then it says they cannot have employment in the town. Why can a Finance Commission member not be an employee of the town?
So I think the idea here is that the members of the Finance and Warrant Commission are going to be separate from the town, so that they're not invested in one particular board or committee or department. And so that was really to be a clarification.
But the ethics videos that Dottie has us watch every 2 years takes that into consideration.
In my experience, it's very common for finance committees not to be able to serve on additional boards independently and not to be employees of the town.
Did you say serve on additional boards?
Yes, independently. I'd like to serve on the Finance Commission and another commission.
Ex officio.
We're going to provide for ex officio if this passes.
I was just saying that in my experience in many other towns.
Oh.
Yeah.
Okay, and just one follow-up. Sometimes it says the individual, the elected official will serve without compensation. In some places, it doesn't mention that.
We
Should
tried.
that be?
Yes, we've updated that, and what we were trying to do, we found that it kept appearing in certain sections, the same language, and we're putting it on top. If you have something in particular you've noticed, or in the next round when you get it, let us know beforehand, because we want to make sure that we get those.
All right, I'll wait for your final draft. and then
Okay.
We'll go through it all.
Okay.
Right, thank you.
I mean, you can vote on something that's going to be amended and presented in
Very
a final
interesting.
form.
There's a balance on the board. I always rely on Jim because I know he will be very thorough, which is actually very helpful. I mean, he brings that approach. Then you just have your last one, your housing authority, or are we done?
We have the housekeeping article. This is really meant to be like where we renumbered things, so we
Okay.
changed from Roman numerals to letters. I mean, we really didn't want it to be anything that required word changes that provided any difference in anything. You know, we just really want it to be incidental matters. Did you want to say something? It looked like you were ready. Okay. All right, that's okay. And lastly, we have a housing authority. We have elected people on the housing authority. All our other elected boards are in the charter. This one wasn't.
Okay.
It was caught. We want to put it in. That's the end of the story.
And does that change anything from the town's perspective or the housing authority's perspective? Does it become eligible for funding from the town or nothing?
It just puts it where it belongs in the document, in our guiding document as an elected board. You know, every so often you find things, and you hear from the planning board that just were oversights, and this one, I think Dottie found this one and said, oh, gee, we need to put it in.
Well-
So, anyway,
You said thank you to us. I want to say thank you to you and I know you have put in 2 years of work. I know I've sort of watched it from the beginning. My absolute compliments on your willingness to listen to people, your flexibility, and I think the town can be very proud of the work you've done. And we're going to nominate you to do the bylaws.
we're in the room, you can't do that. It's when we're not in the room that happens. I'm going to do
I
a
know.
commercial like Mike did, but, you know, it's really been a great committee, and we kind of call ourselves nerds. We actually like this stuff, so it's been a good working group, and we appreciate the time that you've given us tonight.
The current charter allows you to look at bylaws as well as the charter.
But also, Attorney
I think our
Gilbert,
work is
thank
done
you.
here tonight.
Attorney Gilbert, thank you.
Thanks for your time.
Thank you. Thank you.
Do we have to close?
Okay, with that, we are going to go to the planning board, and I always feel a little bit remiss at the end, because we always make them wait to the end, and it's probably one of the most thorough, detailed presentations we get. So Nora, welcome. I see,
I'm going to ask the charter. Here's
yeah, yes,
George, do they have to close anything?
what?
Do they have to close anything?
No, Nancy, do you have to close anything, your meeting? Do you have to close your meeting at all?
Ask Rob.
Are you gonna, Nancy, is anybody going to stay in case we have questions from the public? I hate to do it, but if somebody could stay a little bit. That's a good point. All right.
You got 10 minutes.
I want to welcome, I see you, we have Nora, we have our town planner, welcome. We have a chair of our, and who else do you have with you? I see Phil.
Amanda Wolf.
Hi, Amanda, how are you?
Planner Elijah Romulus.
Elijah.
Chair Ellen Rawlings.
Ellen.
We have members Phil Giordano, Kate Nee.
Kate, where are you?
I think she's here. I think
Okay,
she may
all
have
right.
just. And Chris Paff as well.
Paff.
I think they're out in the hallway, so
Okay, well,
they'll
welcome.
need to come in so we can call the planning board meeting to order.
Okay. Hi, Kate. Welcome. Mr. Paff, welcome.
Great. Thank you. If I may, I'd like to start, this is a continuation of our public hearing, and it is an official meeting for the planning board, so I would like to call the, what is today's date? February 26th. meeting-
27th.
27th, sorry. The February 27th, 2024 meeting of the planning board to order. We have with us this evening board members Chris Paff, Kate Wynn, Phil Giordano, and myself, Ellen Rawlings. We also have town staff that has been introduced, but Amanda Wolf, Nora Luckname, Elijah Romulus. And we have, aside from presenting to you, as I said, this is the continuation of our public hearing. The public hearing on zoning bylaw and general bylaw amendment articles for the May 2024 annual town meeting continued from February 13th, 2024. Procedurally, I think we're good, right?
We're good.
Okay.
All right, so I will begin the presentation. Chairman Rawlings will jump in at some point and explain to you some of the process involved, and the other planning board members may speak at when appropriate to do so.
Okay.
So we'll begin by talking to you about the 6 articles that are on the planning board's agenda for the current town meeting. The planning board actually requested 7 warrant articles be listed, and then removed one of those warrant articles, the housekeeping article. So the select board voted at last night's meeting to remove that unneeded housekeeping article. So the planning board's articles this year are, 1, the zoning bylaw amendments for the Mumford, that's our mixed-use multifamily residential overlay district. Planning board Article 2 is another zoning bylaw change for wireless communication facilities. 3 is a zoning bylaw change relating to definitions and illustrations. Planning board Article 4 is a zoning bylaw change as well. That replaces specific references to parcels with zoning map references. Planning board Article 5 makes changes to the zoning bylaw section on accessory apartments. And then finally, planning board Article 6 is a general bylaw amendment affecting temporary construction dumpsters. So first, beginning with a discussion of planning board proposed Article 1, the Mumford mixed-use multifamily residential overlay district expansion. And this is by far the most complicated of all the articles, so I'm sure this is the one we'll spend the most time on. So I know many of you know this because we've spoken on this a couple of times, but several residents probably aren't as familiar with it as you are. In 2020, the State Zoning Act amendments were enacted by the legislature to promote the production of multifamily housing within walking distance of public transportation. It was done to serve a regional housing shortage. The law was signed into law by the governor, I believe, in January of 2021. And the law itself is actually quite brief and compact. It simply requires that an MBTA community shall have a zoning ordinance or a bylaw that provides for at least one district of reasonable size in which multifamily housing is permitted as of right. The key components of this law are that the MBTA communities, Westwood being one of them, must have at least one zoning district of reasonable size. That district must be located within a half mile of a train station or a bus stop. In our case, it's a train station. That the district must allow housing that's suitable for families with children. No age or bedroom restrictions are permitted. There must be a minimum gross residential density of 15 units per acre, and multifamily permitting process cannot be discretionary. So in Maytown meeting in 2022, the voters adopted Article 22. Article 22 approved our first Mumford district. So the article that was approved then was an effort by the planning board that took over a year before that. So as soon as this law was adopted in 2021, the planning board got to work on establishing a Mumford zone to comply with the law. And that came to fruition in May of 2022. The Mumford district that was approved by voters in 2022 has only 5 parcels, however. Those parcels amount to 16.16 acres. The guidelines that were eventually promulgated by then the Department of Housing and Community Development, now known as the Executive Office of Housing and Livable Communities, required greater than 16.16 acres. So to show you what we have in place now, our current Mumford zone has land on Everett Street, which is known as the former Foster Brick property at 22 Everett Street. And it has 2 parcels along University Avenue. One is the Gables development, and one is the Pulte Homes University Place development. Westwood's current zoning has these requirements. Environmental impact design review approval is required for any application under the Mumford zone. A application is required for proposals under this zone, and they have to have a density of up to 15 units per acre. The planning board public hearing process includes the standard abutter notification that all EIDR, Environmental Impact Design Review, applications require. There are height, setback, parking requirements, landscaping, drainage, lighting, aspects of all projects are reviewed by the planning board. 15% of all the proposed units that are applied for under the Mumford zone are required to be affordable units, leaving 85% of the units as market rate. 10% of units under a Mumford application must have 3 bedrooms. That is a requirement of the state. And the special permit process is available to applicants who want to request approval of applications for density that exceeds 15 units per acre. So that's what we have in the current bylaw. The Mumford section was adopted in 2022. The MBTA community guidelines were finalized after we adopted that zone. They were finalized in August of 2023. And upon finalization, they listed Westwood as a commuter rail community. Commuter rail communities require 15% of the total number of housing units already in existence in a town to be set as the capacity level for this new zoning that's required under the MBTA community law. So in Westwood's case, the 2020 census found that there were 5,801 units of housing in Westwood. 15% of that is 870 units. So the state has told us that our capacity requirement under the MBTA communities law is 870 total units. The Mumford district must also include 50 acres of total land area. And while the law itself required that all of those units be within half a mile of a train station, the guidelines that were finalized in 2023 allow the town to have only 25 acres within a half mile of a train station, and the 25 remaining acres be anywhere in Westwood. So how does Westwood's current zoning comport with the guidelines? The current Mumford district, as I said, is 16.16 acres in size. It has 450 existing units already in it that are developed at University Station, both at Gables and at the Pulte complex. Plus, it has another 160 units that were recently approved by the planning board at 22 Everett Street. So that's a total of 610 units that are either existing or under construction within the Mumford district. However, the MBTA community guidelines requires 50 acres as compared to our 16.16 acres. It requires a capacity of 870 units, and most importantly, it does not count the actual units developed. In determining capacity, it takes a look at the acreage that the town has put into its zone, and it multiplies that by the density that that zone allows. So our current Mumford district is 16.16 acres at 15 units per acre. As such, it only has a capacity of 242 units. So despite the fact that we'll soon have 610 units in the zone, The capacity accepted by the state is only 242. So that would leave Westwood in the position of needing to find capacity for another 628 units and land area for another 33.84 acres. So the planning board set to work to establish a district that is compliant with the state law. Ellen, do you want to take it from here?
Thank you. So the planning board has been thinking about and discussing this legislation for several years now. And we put a lot of time and thought into our initial pass at this last year. And when we realized we had to come back to this, we talked about it quite a bit, and I think we landed on the following kind of guiding principles that informed our process for how to expand what we had already done to become compliant with the state law. So I'd just like to kind of hit on what informed how we landed on the parcels that we are presenting to you this evening. First, we want to comply with both the letter and the spirit of the MBTA communities law. We wanted to do something meaningful. We did consider every parcel in Westwood. I'm not being euphemistic when I say that. We had lists of every possible parcel in Westwood. Obviously, some of those were not going to be viable from the get-go, but we really did consider everything, and we really carefully evaluated the potential benefits and detriments of each and every parcel. One of our goals was to limit the negative effects on developed residential neighborhoods with whatever we bring forward, to preserve fiscally beneficial commercial development where possible. That's important, I believe, to all of us. To prioritize sites near transit and within walking distance of public amenities like grocery stores, schools, playgrounds, etc. We also really wanted to gain recognition of the 610 multifamily units developed or under construction that Nora has already spoken about. We wanted to develop a proposal with the greatest potential for voter support at town meeting. Part of our process that was very important to us was to achieve,
What happened there?
we lost our presentation.
A sign from God.
Yes.
Okay.
We do have, I believe everyone has a copy of this on paper, so I can just continue without the slides. To achieve board consensus on the parcel list, and we wanted to get there based on extensive discussion amongst ourselves and with town staff, extensive research, and quite a bit of resident feedback. And I will say there was a great deal of resident participation at our meetings, but I had a lot of people reach out to me as well, and I think other board members did, and we made sure that we brought all those comments and questions forward at our meetings. And perhaps the most important overarching guiding principle that informed our process was we really wanted to do what is best for Westwood.
Great. So while this is updating, we'll just continue with the print version. So if anyone doesn't have a copy, there are some out in the hallway. So moving on to the district that the planning board is proposing. They decided to create 4 sub-districts. So where we currently have just the Mumford district as a whole, the planning board is now proposing 4 separate sub-districts. Mumford District 1 would have 15 unit per acre density. Mumford District 2 would have 20 unit per acre density. Mumford District 3 would have 35 units per acre density. And then we would have a Mumford District 4, which would have 15 units per acre density, but would require mixed-use commercial with ground floor commercial establishments and housing above. So Mumford 1 is the district that is throughout the majority of the Mumford parcels that are proposed in the bylaw. Mumford 2 would apply to the Foster Brick site, those 2 parcels on Everett Street, which the planning board has already approved for 160 units. They would be set at a minimum density of 20 units per acre, which is actually slightly less than what's been approved for development. And Mumford District 3, with the 35 units per acre, that would take into account the Gables and Pulte properties at University Station, again, that are already developed at greater than 35 units per acre. So this is our attempt to capture the actual capacity of the developed properties. Just as a reminder, we've been through this before, but some folks at home might not be aware of this, but to see what density looks like. So I've given you some examples in the slide package of different multifamily densities around town for comparison to the proposed 15, 20, and 35 units per acre that are in the bylaw. If you look at the Gables property at University Station, that actually has a density of almost 52 units per acre. The Pulte complex has a density of over 36 units per acre. The Steeple building in Islington Center, the former Islington Community Church spot, has a density of almost 22 units per acre. The Colburn School building right next to us here has a density of 13.6 units per acre, so just slightly less than the 15 unit per acre zone. The other mixed-use parcel on Washington Street at 321 Washington Street has a density of 12.6 units per acre. And 401 to 409 Washington Street, a former apartment complex that turned into condos about a year ago, that has a density of 8.6 units per acre, so just a little bit more than half what would be required under the 15 unit per acre density. So next slide has the current zoning map in comparison to the proposed zoning map. And this shows the current Mumford zone. I know it's very hard to see on your pages there, but the current zoning in this first slide shows in the area of Everett Street, the Foster Block property is the only district in Mumford, under the Mumford zone now. The proposed zoning would have 4 different districts in this area. It would maintain the Everett Street property as a Mumford 2 district with 20% density, and then it would introduce 3 new zones, each of which would have 15 units per acre density. One of those is up by the Budget Inn.
Virtually impossible to see the map. There's no way
Yeah,
we
we
can.
can't.
Okay.
It's illegible.
Looks like we might be coming
Yeah.
back.
Yeah.
All right, well, we'll pause for a minute and hopefully this does come on.
Evan's coming.
After tonight, can you send us a full page of the map?
Sure, I'd be happy to. It's, yep, it should be available for download as well. I think Victoria has the entire presentation, so she can get that to you.
It's on the zoning amendment page of the website also.
Is the parcel list there as well?
Yes, and the parcel list is in the memo that I sent to the Finance and Warrant Commission last week. That has the language of each of the proposed bylaw articles, and for the Mumford District, it has every parcel that's included, specifically
get it.
listed.
Oh, I'm sorry, I thought you were done. I'll get a question in while we're waiting. And if you want to defer it to later in the presentation, that's fine. So this is all under one article. From what I understand, we're not getting credit from the state for lots that are or would be higher density, but they're not being recognized for one reason or another.
That's the case under our current Mumford District because our zoning only requires 15 units per acre. The proposed zoning that the planning board is coming back with now has sub-districts that have greater than 15 units per acre. And by having that greater density requirement, we're able to take advantage of more units, including all the units that are already approved or constructed.
Thank you, that clarifies it.
Yeah.
Can I ask one additional question? Mumford 1 and 2 were what were previously approved, right? Those two.
No, actually, what was previously approved are in Mumford 2 and Mumford 3 are the 2 districts that were previously approved. They weren't called separate districts. They were called just Mumford in 2022, but the parcels that are specifically listed under Mumford 2 and Mumford 3 are the ones that are already Mumford parcels.
Okay, so-
Everything in Mumford 1 is new.
So Mumford 1 and Mumford 4 should be the ones that are net new
Yes.
for us to discuss.
Yes.
Mumford 2 and Mumford 3.
They're the same,
by town meeting.
right, they're the same parcels, but now at a higher
We
density.
get newer capacity, correct me if I'm wrong, we get newer capacity from those, because like Gables, for instance, we're moving it from 15 units per acre to 35. Even though it's already developed at 52 units per acre, we now get credit from the state for that
Right.
rezoning.
And there's already been someone that submitted a application for the 160 units, is that correct?
Not only has there been an application, but it's been approved. So the planning board granted
building.
approval to that project in December, so that will begin construction shortly.
That's in Mumford 2, correct?
That is now being proposed for Mumford 2?
The
Yes.
160 units?
160 units, which would be proposed for the Mumford 2 district, which has a density of 20 units per acre. 160 units on that property, I believe, comes out to about 22.6 units per acre.
There's 8 acres there?
Just shy of that, I think.
Yeah.
Wouldn't we want to increase that acreage since it's already being,
Developed.
yeah, I mean, why
So-
wouldn't we want the credit for the additional?
We could have unusual numbers like that, 23.2%. We could have several different districts. I had mentioned in the prior slides where I showed you the density.
Yeah.
What am I doing wrong here?
Could we unplug that for the share?
Technical difficulties tonight.
So for those who can't see either, can you, like, can somebody point, like, where is Mumford 1 and 4 on this proposed map?
Yes, so if I
Sorry,
can,
back up. Yeah, these density examples are.
yes, that's what I was trying to show. If you can go back one more.
Want to go back one more?
One more, please. Okay, so if you look at that, the Gables project has a density of 51.9 acres. We could propose more districts to take advantage of even more of those units, but we still need to have 50 acres in our district. And the planning board's proposal, as they've put it together, achieves the 50 acres and achieves the density requirement, so they didn't push beyond that. They adopted districts that they thought would be more likely to be expanded in the future if the town chose to do that. And a density of 20 units per acre, density of 35 units per acre seemed to be a good fit in certain spots in Westwood. So although these proposed districts only have the parcels that are in the current Mumford zone, the Gables and Pulte properties and the Everett Street property, in the future, if town meeting chose to add more properties to these sub-districts, the 20%, the 20 unit per acre density and the 35 unit per acre density seem to be a good fit. So what those would look like, those would look like the steeple building at 20.7 acres and the Pulte property at just over 30 acres, 30 units per acre. I'm sorry that this just is not working. Yeah, do you mind if I work from over here and?
So we could get more credit for the existing places, but we really don't need that credit because we need the acreage.
We don't, as you'll see as we
need the
go
acreage.
on, yes.
Have we thought about perhaps going back to the state and renegotiating the 50 acres?
I don't believe that's a possibility. Westwood is not the only town that's been assigned 50 acres. Almost all towns in the MBTA community zones are required to have 50 acres. The only exceptions that have been made are for towns that do not have available land to develop within their half-mile radius. For instance, if Westwood was set in such a way that its radius around train stations was all wetlands, and you simply couldn't develop land in that, you might get less than 50 acres. But because Westwood has developable land within a half a mile of its districts, the minimum required amount is 50 acres. So I think the state's been very clear that they're not granting exceptions to that.
I'm just really concerned about the influx in potential students and our ability to properly educate, given our space constraints at a lot of the schools.
All right, so on the districts here, so if you look at the proposed zoning, if you can see my cursor, I'm circling around the Everett Street parcel right now that's already in the Mumford zone. So that just goes from 15 units per acre to 20 units per acre.
We can't see the cursor.
Can't see the cursor. And we don't have a pointer, so,
Maybe one down here.
Is there a pointer on the
Yes.
remote?
I'll advance as you need, how about that?
ah,
there
there
it
it
is.
is.
Yeah, we got a
pointer. Okay, there we go for that. Great.
It
And then
doesn't
if
come
you
out on
could
here, though.
point out the Mumford 1 districts, there's one of them up near the Budget Inn. This also takes into consideration the relatively new Shell station, the Dunkin' Donuts, and it takes into account a state salt shed facility. It's directly adjacent to the Islington MBTA station. And because that's state-owned property, the town does not allow us to count it for capacity, but we are able to count it towards our minimum acreage. So that's one roughly just over 5-acre development that could happen there if someone was able to amass all of those properties. Then across the street, there's another district that is the single parcel, the Lambert's parcel, which is about 5 acres. That's currently residentially zoned, and under this proposal, it would have the overlay district from Mumford 1, which would allow 15 units per acre residential development. That could be a mixed-use development, but it would not have to be. And then the last district that's shown on this map is in the East Street area. It's 40 Allied Drive and 100 Allied Drive. That's also proposed to fall within this district. That would all be Mumford 1, with the exception of the Everett Street property, which would be Mumford 2. So this slide shows you what those properties look like today. So going counterclockwise from the far right, the first picture there is an aerial view of the two properties on Allied Drive, 40 Allied Drive and 100 Allied Drive. Then moving further counterclockwise, we have the Budget Inn and the Shell station and Dunkin' Donuts properties on Route 1. Then moving down, we have the state facility. I show you there a view of the entrance off of Route 1, as well as an aerial view of the salt sheds that are right next to the Islington train station. Then there's a picture of the Lambert's Plaza on Route 1. And finally, there's a picture of the old Foster Block building on Everett Street. Then moving into the next section at University Avenue, the map on the left shows the two current Mumford districts, the Gables property and the Pulte property. Those are the only ones that are in the current zone. The map on the right shows proposed expansion zones. Those two parcels now go to Mumford 3, the Gables property and the Pulte property. And all the other properties that are proposed there would be Mumford 1, 15 units per acre. And I think going to the next slide helps to see what those parcels are. The first one on the top right is the Cornerstone building at 1 University Avenue. That's currently an office building, and that is proposed to be within the zone. I don't believe there are any current plans to redevelop that parcel, but it would be eligible for redevelopment if this zoning bylaw is approved. Then we have the Brigham and Women's parcel that has the Brigham and Women's office building. Moving clockwise further down, we have the Makita Investments building at 80 University Avenue. The next building is the Bridges Memory Care Facility, which is already residentially zoned and residentially used. So it wouldn't be that much of a stretch if in the future the Bridges organization did not continue use of that memory facility. Then moving on, we have the two existing properties, the Pulte condos and the Gables apartments. And now the final part shows our Mumford 4 zoning. So the current zoning on the west side of Westwood along High Street, there are no Mumford parcels today. Under the planning board's proposal, there would be 2 Mumford 4 parcels. These parcels would be one at the Good Plaza, that's the property that starts with the post office and ends with the toast office on High Street, and the other one is the Mackenzie property, which has Dunkin' Donuts and Westwood Pizza, Get in Shape for Women, that parcel. 2 parcels which some might argue would be good sites for redevelopment. In this proposal for Mumford 4, these properties could be redeveloped at a maximum of 15 units per acre. However, there would be a requirement for ground floor commercial uses. So they could not turn these parcels into purely residential use. They would have to maintain the ground floor commercial uses, which really makes them very similar to the existing zoning. We have them, both of these parcels are already covered by our flexible multiple use overlay district, which already allows residential above commercial. So it really isn't much of a change for Westwood. The state would allow the town to take advantage of capacity in our Mumford 4 district, but not acreage. And then this is just a view of showing what those properties look like. The one on the top is the Good Plaza, and the one on the bottom is the Mackenzie Plaza. So the articles that are proposed in the proposed Article 1 for the Mumford multifamily residential overlay district would do all of the same things that the original district that we have today does, have the same EIDR requirement, same hearing notice, a butter notice requirement. The planning board would still look at height, setback, parking requirements, drainage, lighting, landscaping. It would still be 15 units. 15% of the proposed units would have to be affordable, leaving 85% market rate. 10% of the units would still have to have 3 bedrooms, and a special permit process would remain available for any applicants who wanted to have the planning board consider applications for greater density than what's required in the district. The planning board has discretion over those special permits and would not have to issue them. So that is the nuts and bolts of the planning board's proposal for Mumford. But if you have any questions, I'm happy to answer them, as our planning board members, our town planner, and our housing planner.
Jim?
So how many acres are you adding, and how many total acres will we have applied to this MBTA zoning?
Amanda, do you want to take that? Do you have the numbers in front of you at all?
Off the top of my head, I believe it's roughly 68 acres, and the unit capacity, I believe, is in the 1,100 range. I don't have it in front of me, but I'm pretty sure that's what it is.
So to Christina's point, and if we're looking at 800 units and 50 acres, why are we exceeding it by such a far amount?
So one of the reasons why we're exceeding it, the planning board looked at different parcels, and there's total acres that are allowed, and then there's a calculation that the state does where they remove wetlands, they remove property that's owned by the state or the town, or in one case, they remove the acreage of the Brigham and Women's property because it's, in their estimation, a hospital, although it is not. It's actually a medical office building. But there are several areas in the guidelines that have land that's I'm trying to think of what the term is, excluded land. And so while the total acreage exceeds 50 acres, the acres by the time you take out the excluded land is pretty close to 50 acres. So the planning board went through a lengthy process of adding and removing parcels from a spreadsheet to get to this final selection. And the selection was chosen because it was the least number of parcels that achieve the goals of reaching compliance and having a district that meets the other requirements of the guidelines. For example, one of the requirements is that no sub-district can be less than 5 acres in size. So in some cases, we might need to bring in more acreage to a sub-district so that we get to 5 acres. The one exception to that is our Mumford 4 district. The mixed-use districts, there is no size requirement for those, so we can have individual units. But for instance, the Route 1.
Why 300 units more than is required?
Well, it just works out when you get the capacity. You have to get to the 50 acres, and by the time you get to the 50 acres, and we have the larger capacity in certain districts, we get more capacity out of it.
Why
So
wouldn't you change your zoning density in your, instead of, what is it, 30?
35 in Mumford 3, 20
Right.
in Mumford 2, because we're trying to capture the units that we have now. We want to be able to capture the capacity. What we have to do after the planning board finalizes their article and it gets to town meeting, there's something called a compliance model that we have to follow with the state, and we have to give them the parcels. We have mapping, our GIS specialist is creating mapping to show the limitations on all the parcels that are proposed here, and then the state will determine if we're compliant or not. And we believe we have to exceed the 50 acres and we have to exceed the 870 unit capacity in order to get units that are actually approved by the state as compliant. So it's kind of it's a delicate dance looking at the parcels. The planning board reviewed this at its meeting on February 13th. And if you'd like to take a look at the tape from that's available on Westwood Media Center, you can see all the iterations where the planning board went back and forth, and you can see the numbers changing on the spreadsheet. It was a very specific charge to go through all the different properties and determine what would comply and what would not. And we're still now waiting, after we complete this, we still have to go through the compliance model to make sure that the state agrees.
Can I add a point or clarifying point? So the gross allowance is now 60-something acres and 1,100 units, but the net effective that counts is closer to the 50 and the 600.
Closer to the 50 and the 870,
Yeah,
yes.
870.
It is higher, but not significantly
So
higher.
it's over, but it's over because of just some of the properties that are included.
Yes.
Not by, not as that it was the objective to exceed
Right,
either.
exactly. So this was not an attempt to achieve more acreage or more capacity. It was an attempt to comply with all the different requirements of the guidelines, including requirements of at least 25 acres within half a mile of a train station, a requirement of a minimum 5-acre parcel, a requirement of contiguous parcels in other districts.
I found the list, I was thinking of earlier numbers, so it's slightly lower. It's 946 unit capacity and 65.72 acres.
It's only 76 over, and what I watched that whole planning board meeting, what I recall was that you all did, I think, a great job really thinking a lot about this. I recall you trying to evaluate a lot of the trade-offs and trying to hew as close to some of the numbers as possible after you take out some of the acreage that the state would disqualify and leaving just enough wiggle room, hopefully that during the review process, those 76 units give us a little wiggle room in case something gets disqualified. That was my understanding.
Yes. And there were several other parcels that the planning board looked at, and that individual parcels that had support from more than one planning board member, but not from all 5. And one of the reasons the planning board limited it to the parcels they had was they believe it is most important for the town to achieve compliance by having an article pass that has at least 50 acres and a capacity of at least 870 acres of potential housing units in the future. That doesn't mean that's where the planning board thinks this should end. If town meeting approves this bylaw and we become compliant and the state approves us as compliant with the law, there may be future articles that the voters will get a chance to consider. Maybe there are other parcels in town that might be appropriate for multifamily housing, and maybe there are different parcels. So in the future, all zoning can change year to year. So what we need to do is we need to comply, and in the future, if there are better ways of complying that residents would like to see, that's always on the table as well.
If for any reason we're not in compliant, if they reject anything and we're not in compliance, do they give us a grace period? Or do they immediately whack us with their?
So the guidelines
funding?
do not contain a grace period, but I will say that there's a recent example that's been in the news of Milton. Their requirement was to comply by December 31st.
But they show no effort to comply.
Well, I believe they're I don't want to spend time talking about another community, but they did have a representative town meeting that voted in what appeared to be a compliant set of parcels. And in fact, the state had determined that if they got all the information to them, the state believed those were compliant parcels. However, someone challenged that. They had a referendum, and in the referendum, they overturned that. Very different circumstance than what we are in today. But my point in bringing that up was that the state required them to be compliant by December 31st, but allowed them a little bit of informal additional time to reach that compliance. And if the referendum had been successful in upholding the representative town meeting vote, in February, I believe the state would not have would not have taken any negative action.
Nor, just as a point of clarification, we don't get penalized by the state. They just don't give us any funding. They don't send us a penalty bill. It's they may just not give us additional funding for a road or whatever they may.
It's actually quite a bit more than that. So the state has
That's-
determined that all towns that are in MBTA communities must comply. They shall comply with the law, and they have determined that it's not just the three, or I don't remember how many grant programs that are listed in the law that you would be ineligible for, but it's all grant programs that have any discretional funding. The state will make you ineligible for any other grant programs, and the Attorney General will file suit. And that's exactly what happened today for Milton. Milton was named in a suit by the Attorney
Okay, so
General.
it's the filing the suit that's the kicker.
They also pulled funding.
The pulling the funding, I understand, but the filing the suit is the penalty.
Well, it goes beyond that. So if you read through the filing that was made today, the Attorney General asked the court to declare that Milton and all communities within the MBTA are required to follow this law, asked them to determine that it's not just the grants that are listed in the law that they become ineligible for, but they become ineligible for all grants. And then it goes a step beyond that. It asked the judge to determine that the Milton is in violation, and for so long as it remains in violation, it orders that the building commissioner in Milton may not enforce the zoning bylaw in a manner that's inconsistent with the state law. What that means, if that happened to Westwood, what that would mean
Big
is that
Brother's
if
being a
someone
bully.
wanted to put in affordable, multifamily housing anywhere in town, they could do that if we didn't comply by adopting a district that shows where it goes. And one more thing that the Attorney General's suit asked the judge to do is allow Milton no more than 3 months to come into compliance, and if they don't, ask that there be an appointed, a special master to develop the zoning for them. So that's not a position I think we want to be in. Westwood Planning Board has worked very hard to create the first Mumford district, and now to propose refinements that'll bring the town into compliance, and that keeps it in Westwood's control. So now it'll be before the voters to determine if they agree with the planning board that what they have proposed is the best thing for Westwood to do.
Okay. Oops, yes.
I have a quick question. So I understand 25 acres have to be within half mile of the MBTA stations, but what percentage of these Mumford areas are specifically in Islington?
I think it's probably about 85%. The only properties that are on the west side of town are the 2 Mumford 4 parcels that are proposed for the ground floor commercial use. The rest of it is all on the east side of town, close to the train station. The planning board did look at other parcels. They looked at parcels on the west side of town, and they spent a lot of time discussing one particular parcel, but in the end, the board found that they only had consensus if they went with the parcels that were closest to the train station.
So most of them are just going to be consolidated in Islington?
On Route 1 primarily,
Yeah.
Route 1, East Street, and University Avenue.
But for a point of clarity, especially for those concerned about like growth in that area, there's already been 610 units built or under construction that we weren't getting accounting for, that were already approved via the special permit process.
So 2 of
that right?
the Everett Street ones were approved through a special permit, a Mumford special permit. The 2 at University Station were approved by right, not through a special permit process. They were specifically approved by town meeting under the University Avenue mixed-use district.
But they've all of these units have already been built or approved via special means outside of typical permitting. So they've been built.
So the ones at University Station have been built. In fact, the Gables ones have been in place for almost 10 years now. And the ones at Everett Street will be built in the coming year.
You just said East Street too. Where?
East Street, yes, East Street Allied Drive. So if you go at the East Street Rotary, there's 40 and 100
On the other
Allied
side,
Drive.
yeah.
So these are the new districts that are added. So we have more land is added at University Avenue, the Cornerstone property specifically, and then some properties within University Station. The Makita property, the Brigham and Women's property, the Gateway Park, the Wellhead Park. Was there anything? I think that was it at University Avenue. And then New parcels are proposed at Allied Drive, near the East Street Rotary, at Lambert's, at the Budget Inn, and the Salt Shed property. And then, in addition to that, there are the 2 smaller parcels on High Street.
Has there been an analysis to attempt to estimate the impact to the town's finances going forward as a function of?
So this is zoning, not development. You can do a fiscal analysis based on development. There's no way of knowing what would come out of this for development.
Right.
And in the case of the High Street properties, there would be no difference between what's already allowed under the flexible multiple use overlay district than what's proposed here. At University Station, we have properties that are already developed under University Station, and it's pretty difficult to know if any of them will turn over in the future, and if they did turn over, when that would be, and then what the fiscal impact would be. However, the town, if a property is proposed for development under this bylaw, the town will have to do a fiscal study at that time. And the reason we have to do the fiscal study is because the state law allows us to only capture 10% affordable units at a property unless we prove that it's fiscally viable for 15%. Westwood has all of its special permit development throughout the town under every other zoning district, has a minimum of 15% affordable housing. And so we're applying that here, and we have every reason to believe it will be fiscally appropriate on any proposed Mumford property in the future.
Look, it's a very complex issue. I commend the planning board for addressing this and trying to protect the town in a very reasonable way. So I'd like to get through the other articles and give you out of courtesy for all the work you put in. And we will have time to, when our subcommittees come together, and we'll, develop our recommendations at our final public hearing. But clearly a complex issue. I do not think we want to be in the position of Milton. I think the planning board and staff really made a yeoman's effort here to find a way to comply at the end of the day, to protect us as best you can, yet comply with the intent and actual wording of the law.
Just one more thing I want to say on the Mumford zone. We were one of the first communities to adopt a zoning that met the MBTA requirements. While we didn't have 50 acres, we only had 16.6 acres, but we got started. We got started early, before the guidelines were even approved, and more importantly, we, I believe, have the first development that's happening under the MBTA project at Everett Street. So Westwood has been out in front of this from the beginning. We have been diligent in making sure that the town complies and making sure that we do the best thing for Westwood.
Okay, should we go through your next article?
Yes, so this is Article 2, and this one proposes amendments to Wireless Communication Overlay District. Right now, the Wireless Communication Overlay District covers all of University Station. However, the University Avenue mixed-use bylaw, under which that property is developed, does not allow wireless communication. If you've driven over there and tried to use your cell phone, if you know anyone who lives in the University Station area, you'll know that the cell phone coverage is terrible. So there's definitely a need, and we have heard from 2 carriers already that would like to put rooftop antennas on Gable's property and on the hotel property. So the planning board considered this article, and they're pushing forward with it. This would allow rooftop wireless communication within the University Avenue mixed-use district, and would also allow up to 2 monopoles somewhere in the district. It would still require that the monopoles be stealth. I've shown you some pictures here of options of stealth facilities. It could be a flagpole, it could be a chimney on a rooftop, or it could simply be a concealment canister. Right now, on other properties in town, if you have rooftop cellular, there's no requirement to put it in a stealth canister. The planning board thought it was important at University Avenue, where we've taken such care to make sure the development is very architecturally appropriate, to make sure that any cell towers that are added there would also be architecturally appropriate. So this proposed article also adds 2 additional properties that the planning board has been asked to consider for emergency communication specifically, to include 2 other parcels within the wireless communication overlay district. Those are the June Street Playground and the Pheasant Hill Conservation Area on the west side of town. So there's right now a significant gap in coverage that's negatively affecting our emergency communications. our police and fire are looking for a place where they can have additional cell communications in that area. They're not only looking in Westwood, they're also looking in Dover. So they might find a site somewhere else, but they asked if we would help by zoning these two parcels. So I've got some images here to show you what that would look like. This is the image on the right is the entrance to the Pheasant Hill Park and the June Street Playground. And the image in the center is an example of a stealth cell tower that looks like a tree. I'm sure you've seen many of these on the highways. Some are better than others. But if it's placed in the right location in a grove of trees, you would never even notice it. So it might be a way to achieve greater communication in that area without negatively affecting the land. Any questions on that article?
Just on the university station, is there a reason, and if there was, can you share what it was as to why we didn't permit these when the development was initially?
I believe the developer didn't want to. They didn't feel they needed to. It wasn't in their plan for what they were looking to develop, and so it just was never added as a use that's allowed. That bylaw is a little different than the rest of our bylaws, where it very specifically excludes uses. Any use that's not specifically mentioned in the bylaw is prohibited. And so that, they didn't mention wireless communication, but since that property has been developed and people have been living there for now over 10 years, they're finding that they have a need for better cell communications. And I will say that our emergency services would like to see better cell communications in that area as well.
And then a second question, how did we arrive at the 10 feet above the 2 monopoles and the 36-inch diameter?
So as far as the 10 feet above, that's an existing requirement in the rest of our wireless communication bylaw that applies all across the town. A rooftop antenna cannot exceed 10 feet. And then the 36-inch diameter also comes from the rest of that bylaw, where a stealth monopole anywhere in town cannot exceed 36 inches unless specifically unless that factor is waived by the planning board. So we're putting those same requirements here. And the limitation on 2 within that area was just the planning board thought that no more than 2 would be needed in that area. Keep in mind that each monopole can accommodate up to 4 carriers.
And the 36-inch and the 10-foot are reasonable within what?
They are, and
built?
they're already what's required everywhere in Westwood. So we're just adding the same requirements to University Station.
Thank you.
Okay, next.
All right, moving on, we have proposed Article 3, which is in reference to definitions. So there are several definitions in the bylaw that our building commissioner has asked us to revise for different reasons. The first one is building height, and the only proposed revision there is to add illustrations. We find that homeowners, contractors, and real estate agents do not understand how building height is measured. So rather than having to explain it constantly, the building commissioner, and having misunderstandings, the building commissioner has asked us to put this in the bylaw. There are 2 separate examples. One is for a building that doesn't have dormers. One is for a building that has dormers that exceed 25% of the roof area. So very specific requirements, shows how we calculate average height. Hopefully that will avoid people designing their properties only to find that they don't comply. The next definition is lot width. So the proposal is to change the lot width definition to remove language that allowed the lot width to be measured in one way and replace it with a different type of measurement. So the new definition would say that lot width is the minimum distance between the side lot lines at all points between the front lot line through the extent of the required front setback distance. So if you look at a property now, you have side setbacks. Let's take in the single residence C zone. The side setbacks are 20 feet on either side. The front setback is 40 feet. You would have to have, and the lot frontage requirement is 125 feet. You'd have to be able to measure at least 125 feet at that front line, and then you'd have to push that 125-foot lot line back to the 40-foot front setback. The way the definition is written now, in a case where you have a home already on a property, you have to take that 125 feet back all the way to where the home exists. not just to the setback. It is measured to the front of a structure. So it just doesn't work as well, especially for some properties with homes that are set very far back. They have to maintain a greater frontage than a property that has a home right at the setback. So that's the reason the building commissioner requested this change. The next is for the definition of rear yard. There was just an S left off the word sidelines, and so we're adding that S. Detached accessory structure, there was no definition for this, so the building commissioner has asked us to add this definition. A detached accessory structure would now be defined as a structure which is not physically attached to any primary structure on the property, is located remotely from that structure, and is self-supporting freestanding. The use of accessory structure shall not be dependent upon the primary structure, and physical access must be independent. For example, a deck which is not connected to a house but can be accessed directly from the interior would not be considered a detached structure. So to explain what that is, there are some builders who get a little bit cute and they build a deck. So let me start by saying the setback requirement, say for your rear setback. Your rear setback might be 30 feet for a principal structure, but for a detached accessory structure, like a garage, it's less than that. It may go down to 10 feet, for instance. And a builder might put a deck and leave a 2-inch separation between the edge of the deck and the wall of the house, and say that that deck is not part of the principal structure. It's an accessory structure, and so it should be allowed to be within 10 feet of the rear lot line instead of 30 feet. So it's a way of frustrating the requirements, and this definition explains how the building commissioner interprets the bylaw and makes it clear to people that if you add a structure that you attach to the house, it's part of the principal structure. The next definition is for retaining wall height, and the proposed definition defines retaining wall height as a retaining wall's height is determined from the bottom of the footing or lowest level of constructed support to the top of the wall. In the case of 2 or more terrace-style walls, if the distance between walls is less than twice the height of the lower wall, they are considered the same wall/structure. If the separation distance is more than twice the height of the lower wall, they are considered as separate wall structures, and we add an illustration. So here shows a wall and a fence, and as long as the separation between the two is significant enough to be twice the height of the wall, they are considered separate. If it's less than that, they're considered one structure, and the limitation in the bylaw that says you can only build a fence or a fence on top of a wall that does not exceed 7 feet in height, that comes into play. There are cases where there are places in town where people have fences on walls, and you don't always need a permit to build a fence, depending on, or to build a wall, depending on how it's, the particulars of that situation. And so in some cases, people go ahead and construct their walls or fences without checking in with the building commissioner and find that they're in violation. So the attempt here is to put something very clear in the bylaw that everyone can understand and avoid any misunderstandings in the future. The next definition, I guess that's the one I'm actually getting at. The first one was the definition just for fence and wall height. The second one is for combined wall and fence height. Combined wall and fence height. When a fence is installed adjacent to and above a wall, retaining or otherwise, and not separated by a distance equal to the fence's height, the wall and fence shall be measured together. If they are separated by more than the height of the fence is determined to be independent of the wall for the purpose of determining height. See illustration, and here's the illustration that shows that. I'm thinking I have those backwards. That looks like that's the one for the 2 walls, and the other one that I just showed you was for the wall and fence. So I will swap that out. I'll correct that in your next version. The next definition is for affordable housing, affordable dwelling units. So we have a definition in the bylaw already for affordable housing, and this comes into play in every special permit that the town has in its zoning bylaw related to housing. Each of those individual sections, whether it's the FMUOD section or the University Avenue section, the residential retirement community section, the open space residential development section, they all have the same section that describes what is affordable housing. We're pulling it out of those individual sections and we're putting it into the definition. So we only have to say it once, and we make sure that if any of those different sections are amended over time, we don't change the meaning of affordable housing in those individual sections. So we pull affordable housing out, define it as affordable housing / affordable dwelling units, and we put it in one place. So it's very clear and very consistent throughout. And this would also be the same definition that would now apply in the Mumford district. So we've taken language that's in the current Mumford zone and we've moved it into the definition section of the bylaw. And this is a chart that goes along with that. That chart currently is in open space and residential development, residential retirement community, Mumford, several other places, and it specifically shows people how they calculate how many units 15% equals. So if it's less than 8 units, we don't require any affordable housing. If it's 8 or more units, we do, and this shows how many units, depending on how many units of overall housing you have. Any questions on that article?
So is your, your graph here, is that the graph is being added or the definitions
Here,
of how many units is being changed?
None of it's being changed. It's being moved from the individual sections to the definition section. So if you look at this slide here, this is the definition, and it's followed. This is the continuation of that definition. I just couldn't put it, it didn't fit on one slide. So it's the definition that explains what affordable housing is right here, and then the illustration of that definition that shows how many housing units you'd have to build, how many affordable housing units you'd have to build under certain conditions.
And that's the current.
That's the current. It's not any different. It's just,
definition. Okay.
rather than having it in 4 or 5 sections of the bylaw, we're moving it to the definition section.
Okay, last one.
Article 4, not quite the last, we've got 6, but we're getting there. This proposed article takes map references out of the bylaw, or takes specific parcel references out of the bylaw and replaces them with map references. There are 3 sections of the bylaw that have specific parcels listed. That's the Adult Use Overlay District, the Wireless Communication Overlay District, and the Substance Rehabilitation Facility Overlay District. This proposed amendment does not change any of those districts at all. It just takes the specific reference out of the bylaw and references the zoning map instead. They're already shown on the zoning map. So in the case of the Adult Use Overlay District, the current bylaw has that last sentence there. The AUOD is located on the following parcels as shown on the Board of Assessors map. 38, lots 3, 4, 5, 9, and 14 as of May 5th, 1997. We strike that, and we simply say that they're as shown on the official zoning map within the Adult Use Overlay District, which is generally located east of University Avenue in the vicinity of Yale Street. So, and Dartmouth Street. So another reason to change this, by referencing specific parcels, when the parcel addresses change, when the parcel numbers change, or the use of the parcels change, it's incorrect in our bylaw. So looking at the next section, this is the Wireless Communication District, and that used to refer to very specific zones as well as specific parcels. I don't list them all here, but we take the zones out, we take the parcels out, and we simply say it's as shown on the zoning map. And then in the third one, the Substance Rehabilitation Facility Overlay District, that also had 5 very specific parcels. Those parcels are mapped, and now we simply reference the official zoning map within the Substance Rehabilitation Facility Overlay District.
I just had a quick one on this one. I assume that there's no room for misinterpretation in terms of a parcel being in a certain zone, because obviously using parcels and plots is specific, using a visual can be less specific. But
well, we have our visual is our ArcGIS map that's tied to specific parcels. So if you call up that map on our bylaw, it shows you very specifically the parcels, and they're delineated by parcel number as well as, so that there's no way to confuse it. Okay, Article 5, this is the simplest one, accessory apartments. Right now, accessory apartments have references of floor area. We're adding the word gross floor area. This is to alleviate misunderstandings where the building commissioner has And the previous two building commissioners have also always interpreted the floor area measurements for accessory apartments as gross floor area, all the area within the walls of the building. Some builders don't think that's the definition, so we're making it clear in our bylaw. We're trying to get ahead of things and make sure that when someone looks at a property, they understand what they can and cannot do with it. In the case of accessory apartments, there are limitations where an accessory apartment must be between 500 and 900 square feet. If you miscalculate that, you may not be able to get approval. So we want to make sure people know from the beginning, when they first consider it, that the building commissioner will measure gross floor area.
So Nora, the difference being interior walls are counted as gross?
So they take the gross area they draw a box around the entire apartment as opposed to excluding closets, excluding stairways, excluding the thickness of a wall.
Yeah, okay.
All right, and now we're to the last one. This is, the first 5 were zoning bylaw amendments. This one is a general bylaw amendment. We were here last year with amendments to the solid waste section of the general bylaw to put requirements on dumpster enclosures, dumpster maintenance. What this does is it adds to that, not just permanent dumpsters, but temporary construction dumpsters. This is only applicable to non-residential and multifamily residential properties, so it doesn't apply to single or two-family homeowners. The requirements are generally the same as far as maintenance and placement of dumpsters. However, where a permanent dumpster requires a full screening and impervious cover, in the case of a temporary construction dumpster, we add a section that says, notwithstanding the above, a temporary dumpster associated with a non-residential or multifamily residential property shall not require integral cover, enclosure, or screening, but shall be covered by a securely fastened impermeable tarp or other means sufficient to prevent the discharge of contaminated runoff or leachate into the soil, groundwater, or surface water. So the reason for this is just to make sure that the same environmental concerns that the planning board had with commercial dumpsters throughout town, that those are the same concerns, even if it's a temporary dumpster. We don't want rainwater rushing in and chemicals washing out, so that is it. And that's our last article.
Thank you so very much.
Just a general comment, Nora. I know it costs more to print the town meeting book if you have diagrams, but I'm in favor of as many examples and illustrations as you can possibly get.
I agree, and we've benefited from our new building commissioner being an engineer who's capable of drawing those illustrations, so it's been terrific. So now, if there are no other questions, the planning board can continue its public hearing, and for everyone who's interested in coming to the next session, the planning board will meet on March 12th. All of the planning board meetings are by Zoom, and the Zoom links will be available on the town meeting calendar.
Well, we're so glad we give you the opportunity to meet each other in person.
Yes, thank you.
But thank you, really excellent presentation as always, and I know especially that first article, the huge amount of work you have put in, and I think at the end of the day, it will protect Westwood and give us a very, very reasonable chance at getting through the Commonwealth's approval process, so thank you.
Thank you.
Thank you all.
Chairman Hertz, as this is also a planning board public
Okay,
hearing,
right.
if I may, I
Yes, of
need
course.
to open it up to public comment. If anyone would like to ask a question or comment on the articles that were presented this evening, please feel free to come to the microphone. We would just need your full name and address.
Hi. Marjorie Ramo, 48 Clapboard Tree Street. Did that get caught? Great, thanks. I just wanted to know, on page 3, which I don't quite know which slide number that was, it states suitable, that the key one of the key components of the law is that it be suitable for families with children, and then it says no age or bedroom restrictions. Is there any guidance besides that on what suitable means? Would a multitude of 2 beds be suitable?
So the only requirement is that at least 10% of the overall units have to have 3 bedrooms, but the rest can have 2, they can have 1, they can be studios.
Okay, thank you. And then I wanted to know as well, are the slides available online so we can blow them up?
They are, so if you go to the planning board's meeting packet, you will find the entire presentation as well as the specific language of every article.
Great, thank you.
Thank you. Any other members of the public that wanted to ask questions or comment on the planning board articles?
I think you're all set.
Seeing none, at this time, I would entertain a motion from planning board member to continue the planning board public hearing on proposed zoning amendments to our March 12th, 2024 meeting via Zoom.
Second.
I hear a motion and a second. Any further discussion? Seeing none, all in favor? Aye. Any opposed? We don't have to do roll call, we're here. Hearing no opposition, the motion carries. Our public hearing is continued. Now I would entertain a motion to adjourn this meeting.
Second.
I hear a motion and a second. Any further discussion? Seeing none, all in favor?
Aye.
Any opposed? Hearing none, we are adjourned. Thank you.
Thank you.
Thank you.
Thank you.
A few more items for us, and that is on the, we have our subcommittees, our meetings on the 12th. Now, I'm going to ask folks, do you want to do it in person or do you want to do it in Zoom? Preference, the subcommittee reports?
In person.
In person?
I'd prefer in person.
All right, we're going to do it in person, which is fine, I'm glad. And then, so basically, we're in person for the rest of the year.
Yep.
Okay? All right, and then please remember, as you, there really, I'll let Chris address this, but there's sort of the deck presentation you're going to make at the subcommittee reports, but then there's the write-up that has to go into the town book, and they're different, okay? I mean, you can use, summary slides and your community reports. Remember, we got to do write-ups. And I look at what we did last year in the book. You'll get an example of it, okay? Anything you want to add on that, Chris?
No, just take last year's book and cut and paste and change appropriate things.
Okay.
That's all there is to it.
I think we did
ChatGPT, write my
have one
subcommittee report.
comment last year that was helpful about the title of the warrant articles.
Okay.
Just if we could be more sensitive to that. A member of the public talked to us about that with respect to one of our warrant articles.
Do you remember specifically what that was? For some reason, I'm not.
Was it
The
municipal?
sidewalks.
The Cannon Street sidewalks.
Yep.
Right.
Okay.
Christina, we don't control the title of the warrant
Of the
article.
warrant article, okay.
All we can do is write about it in our write-ups,
Okay.
saying that, we wish this would have been said a little bit differently, but it isn't.
Is that one of the articles?
No,
No.
not this year.
Last year.
You want me to get going?
You don't want to touch sidewalks, but let me tell you, if you watch the recent meetings, that's a tough one. Let me think. Any other business that members want to bring before us at this point in time? Okay, with that, can I get approval for the minutes from?
So moved.
So move second.
All those in favor?
Aye.
Nobody opposed? Approved. And then, let me do this, can I compliment anybody, the public who stayed with us. I wish more would have bared the course, but are there any questions you have of us?
Us or the elected officials that are still here.
Sir, just state your name and your address, please.
Good evening, it's late, so I will try and be brief. I'm John Lawrence, also known as Jeff, live at 587 Gay Street. I want to speak in favor of the proposed leash law, which has now been thoroughly gutted. I think the town has missed an opportunity to significantly improve public safety. As noted earlier, the current regulations are 50 to 60 years old. Population of the town has increased. A quick search on Google says it's gone up over 60% in that time period. No doubt the number of dogs in the town have gone up by even much more, particularly after the pandemic. The current regulations are very confusing. We heard a conversation between commissioners. Lieutenant Sheehy of the police department on numerous occasions, including at various CONCOM meetings, has said they are unenforceable. So they need to be clarified. I would also say that the proposed leash law, as originally proposed, is consistent with surrounding communities and state rules as well. So I think the town needs to be more forward-thinking. Right now, I sense it is unwilling to adapt to the changes going on, the changing times and the changing environment, the circumstances, and I would encourage the town and this commission and the selectmen to adopt more current types of policies relating to dogs and leashes. Thank you.
Thank you. Any other questions or comments from the public?
Good evening. I'm Karen Manor, 5 Long Meadow Drive. Got a few comments. Following up on Jeff Lawrence's comment on the leash law, I noticed 2 you active people here were interpreting how it reads differently. So I think that would lend oneself to why would we enact into law something that smart people sitting here have trouble clarifying and have some difficulty enforcing. So that's an observation that I have there. Secondly, also under the select board comments, well, afterwards at the end, there was a follow-up to last night's executive session. There was some discussion with Hale Education and possibly, we don't know anymore what's happening, but I will also then speak on behalf of the Westwood Land Trust. I have talked with your leadership here last summer, offered for the Land Trust and others to meet with your board, your commission, to share any ideas or answer any questions that you may have if something should come forward in a short amount of time. The last item I'll comment on was the great presentation on the charter review suggestions. I served on the 2010 review. Lauren Goldberg guided us back then. She's awesome, as you saw, and some of the items that they spoke to, one being the quorum. I've been one of those people before, pulling people off a soccer field to have us meet 10 more people to get inside for that quorum. So just the whole understanding of the need, why you don't really need that quorum. Does it really matter if you're pulling 5 extra people to stay in for 10 minutes? So I had that comment. And then with open town meeting, I know that was a big discussion 14 years ago. And through our work then, we decided to stick with open town meeting. We had seriously discussed having representative town meeting. And then with respect to having some of those positions changed from elected to appointed, that we just really need quality people and for some of those jobs, as they mentioned today. So again, highly support those decisions and appreciate all you do. Thank you.
Thank you for your comments. And one suggestion I have is that my guess is at when's our next public hearing? At the
26th, March 26th.
26th. That's when that article that we will may have a potential warrant article, and you are more than welcome if you would like to come and address us at that point in time. Okay, so just keep your eyes on what gets published. The reason I raised the issue tonight is we have to engage in that process. I want to make sure everybody, like you and your folks, have a chance to speak. Okay. And thank you for staying for the end of the meeting tonight.
Hi, everybody. Again, Marjorie Rommel, 48 Clapboard Tree Street. I just had one question on the home rule petition regarding the housing authority. It says that the 5-member housing authority to be appointed and elected is required by state law. What does appointed and elected mean?
There's a provision in state law, what it was, that the governor gets one appointment on a housing authority. The governor hasn't always exercised that. The other housing authority, I believe, are kind of selected through who are elected to the housing authority. So it's a combination. So the governor cannot exercise his or her provision to make an appointment at some time. So there's like always an open slot, and we've taken steps to fulfill it. I'm losing my voice late at night. I apologize. So that's, I believe, the genesis of that.
If the governor doesn't make their appointment, do we still have a 5-member board?
Yes.
Thanks.
That was our town council, Pat Ahern speaking. Any other questions or comments? With that, I'd like to thank, before we adjourn, I want to thank the select board members for staying the course with us tonight, and also some of the planning board members and charter committee folks staying to answer any questions. I know it made your night as long as ours, but thank you for staying. The same thing for town council. So with that, how about
I move to adjourn.
All those in favor?
Aye.
All right, thank you all so much.
Was there a second?
Yes.